Pennington County Board of Equalization meeting for April 23rd, 2015 to order. And turn the program over to Shannon Rickberger. How are you this morning?
I am better.
Good.
Thank you.
And purple. I have. It's
Yes.
nice.
Well, good morning. The first thing we're going to do this morning is this list of mobile homes that I told you about. A little bit better explanation of this is that state law requires that whenever a mobile home, new or old, transfers title or moves, and if it transfers title and doesn't move, it still transfers title, that the taxes have to be paid in advance. So, from January 1st till mid-April, if a mobile home, including a newer double-wide, just transferred title, the 2015 taxes that won't be due until next year have to be collected in advance. We do not want to leave the assessment of that home on the tax roll because next year when that tax bill's printed, there will be a duplicate tax. So we try to fix these at this point with the Board of Equalization by giving you the list. These have transferred title and taxes have been paid in advance, at least up until now. Okay, from now on, we're gonna have to create a list and it'll be an abatement for next year, and that's some of what you do at the first part of the year, but we try to eliminate a good chunk of them anyways at this time. So we ask that you change the assessment of these parcels by the amount indicated, which would then nullify that tax next year that's already been collected.
That'd be my motion.
Is there a second? Second. Motion and a second. Discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Okay, on your schedule, the first appointment we have is Robert and Kim Mandel.
Holly wants to speak on that. Where are we at?
Holly? Hey.
2 seconds. Commissioners, the last appointment that you had scheduled for yesterday, that individual did come at 4 o'clock and asked that you guys honor her an appointment at 4 o'clock today. She does want to come in front of the board and talk to you guys. So if that's a possibility, she was going to call me this morning and I would let her know. She just can't leave her employer without a week's notice. So she wouldn't be able to
So
get
she
off
for
work
sure
until
will be here.
3:45.
Okay, because we didn't know that yesterday.
And that's what I told her, and yeah.
Okay.
I don't see
So
any
if-
reason why. That's our job.
If that's acceptable with the board, I will tell her that you will be here for an appointment at 4 o'clock.
We probably won't have appointments that go till 4. The board is required to meet during a certain period of time, and there's more days if today isn't good enough for you.
I don't see any reason why.
What's your thoughts?
Yeah, we've got to let her have her appointment.
Oh, sure.
Yeah.
Or Shannon could relook at it and maybe make a deal with her.
Shannon can't make a deal. The board makes decisions on these.
Let's make a deal, Shannon.
How close to tea time? It's bumping up against it.
I mean, I gave you copies of the paperwork that she gave. She said she hasn't made any improvements, she has no means to make any improvements, and doesn't feel that there should be any increase in her valuation. If there is, she's gonna lose her house. That was what she asked me to relay to you.
And the reason maybe we need to understand, the reason it was increased was just because it was reevaluated in the neighborhood?
I don't know.
Yeah.
Kelly spoke to that very briefly yesterday, and we could, if she appears before the board, we could certainly explain that further.
Okay, we've got to give her the chance.
I move approval.
Yeah.
Me too.
Hey, all right. The first property owner scheduled today is Robert and Kim Mandel, and I expect the next several property owners to be here, but I don't know. Are Robert or Kim here? Okay, let's skip over that one and just go on down to the next one. How about Jim or Kelly Weisgram? Okay. And then Joe from our office will have comments to that. And I will look for Mandel's, and we can come back to that. So we're the second one on the list, Wisecram.
Okay, you may proceed.
Good morning, Jim and Kelly Ham Wisegram, 6531 Sheridan Lake Road in Rapid City, South Dakota. We're here to appeal our taxes from being taken out of the ag status and wanting to be put back into the ag status. We have lived in that residence for over 16 years, and we've been ag status for the entire time. We've always abided by the Pennington County law stating principal use in the 40 acres. If you don't mind, I made a couple copies to show you our aerial map, which is right there too. You want one, Shannon? Oh, Joe, I'm sorry, I thought you. What it is,
Thank you.
just shows it right in the middle of our 40
We
acres.
can share if you don't have enough. Okay.
Thank you.
Just to get your bearing, excuse me, I just want to make this clear. This should have been caught on my part last year, is what it should have been. With all the change in the ag status from going 40, or from 40 to 160, then roll back to 140, I wasn't paying attention, I'll be honest with you. And when they rolled it back to 40, I was reading in the article from the county, it said they were gonna leave it alone until we get these appeals, or this 40 acres all straightened out. And I didn't look at it very close, but I just want to make you aware that it was my fault, that when the assessment did come out, that I didn't see the assessment, and I put it in my file and missed it. So again, I just wanted to let you know that should have been caught on my part last year, I'll be honest with you. Besides the 40 acres that we own right there, my wife's family, and my wife is a partner of the LLC ranch that has over 300 acres that borders us on the backside of our 40 acres. And it's obviously been agriculture the whole time. As you can see on the map that I handed you, both my wife's sisters on both sides of us are fully ag status. Nothing's fenced out in our ranch on amongst all these 40 acres all the way across. So there's not one fence that I'm fenced in, or I'm fenced out, or they're fenced in, or I'm fenced out. So we run ag status, we run cattle, and we've done that since I've lived there for over 16 years. The primary source on our 40 acres is our well. And that well is crucial for our west side of that whole road over there, I'll be honest with you. Those are permanent structures up there. There's corrals, there's loading chutes. We have all the mineral, storage for all the mineral and everything else is all up there. And that's so crucial for our ranch, I'll be honest with you. And you'll see it on some of the pictures, I've circled it, and I think you can be aware of that. We're totally landlocked, as you can see that. We go in our driveway, we cross Leo and Audrey Ham, which they're fully agricultural. We cross our LLC, which my wife owns 1/4 interest in. And to get to our place, then we're on our 40 acres. And again, we're completely agricultural all the way around us, as you can see. To get to our house, we have a private easement. Again, it crosses it. We're not fenced in. We're not running like cattle inside 40 acres. We're running an agricultural ranch that's wide open, as you can see. The only fence is on the back side, and you can see in my pictures there, and I think Joe was out there, he saw it too, is one fence that borders us in the back of that approximately 300 acres. So to say that we're not 40 acres in agriculture, I don't see how I can get from being in there 16 years with no change, same cattle rent that we've always had. As the other standard that Pennington County always says we have to have, 2 of the 3 criteria, is principal use. And the definitions, obviously, is taking place of property of agricultural production. And we do. We rent cattle. We pasture that out in the back. It's really crucial that we've been in that status, and that family's been in that status since the 1930s. This is the third generation of agricultural out here. Leo, my father-in-law, he's raised his kids out there. Now it's our turn out there, living out there amongst that with the cattle in our status. Again, as we're up there, it says profit. Well, this is about the first year cattle prices have been pretty good. We raised the rent. We're gonna, it needs to show profit. And we did, I'll be honest with you. But along with expenses and profit, there is expenses. You know, we have the well, pump, electricity. When that freezes up in the wintertime, we propane that so those cows can drink. Again, we're all agricultural, and I feel on our part of it, we're compliant of what we need to be on the 2 of the 3. There's many times, and it says about like inventory or to prove it. There's times in the winter, we've had 70, 80 cows in the backside of our ranch, in the protection in those draws and those trees and stuff when the blizzards come through there and stuff. We have, on the other side of the road, we'll run 30 or 40 heifers on the other side of the Sheridan Lake Road to show that we're completely agricultural. Besides the expenses, we're spraying the weeds. I'm spraying the weeds. I'm cutting all the bug trees down. The county come out and marks them, which is really nice. And we up in the last 3 years, we've, staying up on all the issues of this, the county and everything else that we have to do to keep this affordable. But that's my appeal of, and again, I'm surrounded by my 2 sisters. They're fully agricultural. Their taxes never changed. But you picked us out on the red and says that of the number 2 of the criteria or principal use, we don't abide by. But that's my appeal.
Any questions by the commission?
Mr. Chair, I do have. So if I understand how this works, it's still all one big unit that Leo started.
Yes.
But, and I've listened to him at some meetings. So this is indicative that each of his daughters got 40 acres as part of a,
LLC.
well, but that's what I'm trying to determine. There's all an LLC, but do the 3 daughters own that 40 acres separate?
Yes.
And then the LLC.
Surrounds.
Yes, and it uses.
Yes.
This property for grazing for whatever you need to
Pasturing.
do. Pasture.
That's
yeah.
true. There's not a fence on that. You
Okay,
cross the cattle,
that's-
I bought 2 cattle guards. They're installed right there, as you can see off the first one off Sheridan Lake Road. It's wide open. And again, amongst the family, we rent that. is what we
Okay,
do.
that's what I was trying to get in my head.
Absolutely.
Okay, thank you.
Any other questions? Joe?
I am recommending no change, and as Mr. Weisgrim has mentioned, the reason that we are denying ag to this parcel is because the principal use of the parcel is the residence of Jim and Kelly Weisgrim, and rather than the agricultural aspect of it. And the Leo Ham LLC is a secondary purpose to the primary residence of their house. And I was on site with them, and Leo and Jim, and they did gave me a great tour of the property and a lot of understanding of the local area as well.
Any questions for Joe?
Yes, Mr. Chair. We're changing one, but not the other 2 properties, am I right?
The other 2 properties do remain in ag status
How is it different?
because there's no residences on those properties.
So my 40 acres and my little half acre that I have fenced out has no bearing on 40 because I'm I'm running cattle all the way around that, as you can see.
For egg, can you have a primary residence on your egg property?
Yeah, sure.
Sure.
Okay, so I don't see the problem. Yeah. I guess, so what was your 2013 tax assessment?
And my 13,
13?
I got it there too, somewhere. My land was valued at $5,000 an acre, was what our 14 assessment is. Now it's gone to $670,000.
The total assessment for 2013 was 268,800. And I don't know how that was broken out. I would assume, I don't know, I'd have to go back. I don't have that broken out.
Any other questions or comments?
You know, Mr. Chair, I am struggling just a little bit with this one, Joe. The way that they have set that up, I mean, again, I've heard Leo talk about how he wanted to give each of his daughters 40 acres. And the fact that they've never fenced it and it still runs as a whole operation, I'm struggling with how we can take egg away when it is part of it. Yes, they live there,
Not the value.
but, I mean, that would be like taking away my dad's house in the middle of his ranching
3
operation.
generations we've lived there, and that's been fully agricultural. Oh, I'm sorry. Nancy.
Yeah, I'm not arguing with you.
No, I'm sorry.
Don't, just let me go. So, here's my struggle with that. I don't, in this case, because I know that they have ranched that for so long, and they didn't divide it, it's still running as a total ranch, even though there's some pieces of property that were deeded to his daughters. I'm struggling with that, and I do think they should be able to have a house. The only thing that I can wonder, well, but that still wouldn't work. I was thinking, you know, if you thought because Leo has his property and has a house, and Kelly and Jim have theirs with a house, does that somehow negate it? But Kelly's is on, I mean, ownership is different. So I'm struggling with this one, to take the egg away.
I'll make
Mr. Chair, I move approval of the applicant's request.
I do too. Second.
I'm sorry.
I move approval of the applicant's request to change to egg status.
And I seconded it.
We have a motion and a second.
On the applicant's request, it was $5,000 land value and $275,000 building value, is that? I mean, that's your
Right.
request.
That's my request on our ag ansel, and then along with my house.
So with the house, though, the house went to 290?
That went along with it, too. I mean, I understand the house is separate dwelling, I realize that, but the assessment, between taking me out of the ag to that, to the land increase from non-ag, then they upped my house from 264 to 290.
But I do believe that they have made an effort out in that area to reappraise, am I right? In the Red Rock
in Red
and
Rock,
Countryside
yes.
North and all that.
But we have you at, say it again, 275, Karen?
No, 290.
On the application, it's $275 for the house and $5,000 for the ag land.
And that was our motion, I think, wasn't it, George?
My motion was to honor the request to change it to egg status,
Okay.
period.
That does not include the value.
A house.
It doesn't include, no,
House.
no.
Okay.
I can work up the egg land value for you later. In 2013, the land value was $4,200. I would expect that it would be higher because of croplands going up over the last
Because of
couple of years, but
5,000.
not significantly.
If any standpoint, if you looked at the land right beside us, the 40 acres on both sides, the assessment last year went from 42 to 5,000. That's how I come up with 5,000.
Okay.
Okay.
Not that I should get better than them or less than them. I'm just saying, I'm side by side with them,
Sure.
is what I am.
Okay.
Okay, are we clear on the motion?
Okay.
Any further discussion? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Okay,
Thanks, Maya.
next item.
We could back up on the schedule. Robert Mandel
Do you want
walked
this?
in. The first name on the schedule is here.
Okay, thank you. Apologize for being late.
So to be clear, it's, we're going back one name
Leo?
on our schedule. Mandel is the name.
Leo, there's more of these if you want them.
I'm sorry. We're trying to get it organized for you.
I might want one
Next
to
year,
come get
Leo.
you.
Sure.
Okay, okay. Proceed, sir.
Sorry. Morning. I think my question about my property taxes is fairly simple. They increased about 8.5% this year from last year, and I frankly think it just wasn't justified from rise in price valuation there. One of the things that was explained to me, it was based largely on the increase in material costs over that period of time, and I think that that's really a fallacious way to look at property costs. It's what things sell for, and I looked at what other properties around there went up and what sales went for, and I think it was simply an unjustifiably high amount. It's as simple as that.
Okay, Kelly?
Patty Castor for Pennington County Equalization. Mr. Mandel's property went up 8.47% from 14 to 15. I did conduct a full reappraisal of all the Red Rock neighborhood, Red Rock Estates, Meadows Village, this past year, and in that reappraisal, I found a lot of data corrections and adjustments for the entire neighborhood. Mr. Mandel and I went through his property in 2014. I got all his data corrections made then. Came up with a value last year of $417,800, which he didn't really feel was a good value at that time either, but didn't pursue it last year. This year, it did go up to $453,200, which is $90,000 on the land, $363,200 on the structure. There is a lot of sales in this neighborhood. That is what prompted the reappraisal. But in going out there and going structure to structure and getting our data correct, and all the adjustments that needed to be made throughout the entire neighborhood, I do feel the value for 2015 of $453,200 is a good value. I do believe that the market would hold that should he put it on the market. I do have sales in Red Rocks of 2 stories, only 2 of 2-story structures, but I have several sales in Countryside South, in Sheridan Lake Highlands of very, very comparable houses of almost identical in square footage and amenities and everything like that, that have actually sold for more than that. And we can go in and start pulling those up if you'd like.
Okay, thank you. Any questions from the commission?
Can we see some comparables, Ms. Luann?
Okay?
Thank you.
Let's start with, well, yeah, let's see. Let's go ahead and let's start with this, and then go to that one. Okay? We'll start with the ones right in Red Rocks Estates. I'll just fill you in while Luann's trying to get it in. This first one we're gonna pull up is graded just a little bit higher than Mr. Mandel's. It has a lot more square footage, and it sold for $950,000. It does adjust in our system down to Mr. Mandel's property as far as adjusting for the grade, adjusting for the square footage.
That's a big house.
That is a big house. Side.
Did you say these were the same square footage as his house?
No, this one
I was
has
gonna
more
say-
square footage than his
I was
house.
gonna say.
This one is graded at a very good plus. Mr. Mandel's is at a straight very good. But this is also right in Red Rocks Estates. This is on Prestwick Road.
And candidly, eyeballing it, I'd say it's about twice the square footage of mine.
But she adjusts that. I mean, there's an adjustment
Yes,
factor.
it does adjust for that. The next one, Luann's going to bring up is also on Prestwick Road. It is a good plus, a little lesser quality than Mr. Mandel's, a little lesser square footage, and it sold for $449,900. So if you put Mr. Mandel's in the bracket between the good plus and the very good plus at a very good, with the adjustment in the square footage, he is bracketed on both sides at the $453,000 that I do have in that.
Any other questions? Any further comments? Are we ready for a motion?
Mr. Chair, I'd make a motion to to uphold the recommendation of the staff for the assessed value of $453,200 total.
Is there a second?
Second.
Motion and a second. Any further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried.
Okay, thank you.
Thank you.
Okay, going down the schedule, the next person is Catherine Peterson, and she is here.
Good morning.
Good morning. Hi, Kathy.
Hi, Nancy. And to thank you all for giving us the time to come speak
Okay,
with you.
you can present your case.
Yep, I would like to appeal the property valuation at our location, and I should have probably caught it last year. I did not. I apologize for that.
Ma'am, you'll have to
But
speak
I'd
up.
like
You have to speak up.
Okay, but I would like to appeal that this year, and I'm going to ask my husband to present this for me.
Thank you for your time. Her concern and mine is the property valuation, the land itself. We don't have a dispute regarding the buildings. I'm going to pass out a copy of her letter and some valuations that are in the area that I think will demonstrate, you don't have the valuations in the area, though, that will demonstrate why we believe that's the case.
Here.
You?
Excuse me.
I'm not sure I have a copy, but if you,
We can share if you want to.
okay. In the packet, the letter is kind of an area map. And if you look, our parcel is pictured there on the screen, but if you look at the topographic map that looks like this, and our parcel is right there about in the middle, you'll see the topography is quite rough. We have a canyon or a draw that goes down behind the property. We were told there was one comparable. It's over on North Star Road. Very similar topography, and it sold for about the valuation. But our contention is one sale doesn't make the market. If you look again at the next one, you'll see the topography. The next one, again, we're kind of focused on Sheridan Lake Road. Looks like this in your packet. And the red parcels that are outlined, all of those are valued at $10,000 to $11,000 an acre. And I've attached the particular details for each parcel behind that. Some of them are 17 acres, some are 10 acres. And I guess I have pictures to show you what those properties look like. Properties west of Highway 16 are more desirable. There's trees, there's beautiful views. The one comparable that they've given us has an outstanding view to the south, down through the Reptile Garden, Heart Ranch Valley.
Casey, you have any egg on this?
No, no, I have horses on it, but that doesn't qualify for, they're just pasture pigs, as they call them. I've been told that the county's median sales to assessed value is 98 point some odd percent. If you follow numbers at all, and I do that occasionally, that means half your properties are valued at less than that, half your properties are valued more than that. So there's a really good chance of having these types of differences. I'm not being critical of the equalization department, it's just a matter of statistics. And so, I don't know how to show you these pictures, but I can show you pictures of the properties that are 11,000 and 10,000 an acre compared to our place. We planted every tree that's out there, and I think there's 6. So, is there any way to hook this up? Your projector?
3%.
Well, we'll see if we can.
Well, I'll walk it by.
Your Vanna today.
Yeah.
So this is,
This is out by Norseman Lane
okay.
on Sheridan Lake
That-
Road.
They shouldn't be just doing it.
This is Norseman Lane. This is around Norseman Lane, shows the neighborhood.
Okay.
Another shot, I think you get the idea, but I wanted to
Raised everybody a certain, usually the average, I
Get
see
this
48%.
pictures on your text.
That's the one that looks,
Yep.
okay.
This is the view from the comparable. Okay, it's $1 million view. That's North Star Road.
You have pole barns and stuff like that on your,
I'll show you here.
okay.
This is the area. Okay, you remember this is Highland Park. Sold for
Hallmark.
$15,000. It's never been developed because it's too expensive. And it's our neighborhood.
You guys ever get water and sewer up there?
No. So this is our, here's a. This is the topography, and I know the county wouldn't let us fill that in. We'd have to build a road to get to the other side of the 5, we can subdivide to 5 acres with covenants. So we'd have to build a road and be careful because it's in the drainage. Deb, to answer your question, I can get it here.
Julie wants an answer.
Because there's a picture of the building that's out there.
Oops. So these are all your barns and different stuff out there.
The red one's not the house and the house. What's that? Oh, there's the neighbors.
Okay.
It was valued in 2013 at 96,200. It's now about 144,000.
Okay, let's see. Dick, do you want to comment?
I'm Dick Maraskin with the Director of Equalization's office. I have some pamphlets to hand out here. Hopefully it'll bring this a little more light on the subject. Property, you guys know where this is at, up on 16, okay, everybody knows. It's a 10.16 acre parcel. It's currently valued on the land at $142,500. The buildings are valued at $180,200. Total is $322,400. It's a story and a half house built 1998. It has 1821 square feet with a wraparound porch, 2.5 bathrooms, fireplace, small unfinished basement, 195 square feet. We have a quality as an average plus. I believe that's correct. And it's an average condition. Plus, this parcel also has a couple farm utility buildings. One is 24 by 45. It has no floor. The value on that's $1,900.
Are you talking about the shed that I keep my lawnmower in?
The shed off to, actually, there's two sheds combined. Yeah, right back there in the white. We have them as one shed, but they're actually two. One of them has a dirt floor. The other one has, my understanding, it's got guest quarters in it. Is that correct?
Yep.
We're going to have to visit this property next year and correct that. We have it as a farm implement building with a value of somewhere around $9,500 on it. But I know we can't raise the assessment for this year, but that should be looked at next year.
So there's basically one building there. I thought you were talking about the little lawnmower shed that's just off the circle, so.
No, we're talking about your farm equipment building back there in the cattle shed. Part of it's got a dirt floor, part of it has a concrete floor, so we've set them separately.
Okay. I guess I don't call it two buildings. My apologies for
Oh, you're fine.
questioning. I do have a skid steer in there and horse stalls and hay on the side that's got the dirt floor.
Yeah, we have no problem with the part that's the dirt floor. We have $1,900 on that. That's okay. But
Isn't
like I
it-
say, we do need to look at the other part for next year.
Well, Dick, isn't it primary use, or is it not? That's only when you're talking about ag.
Yeah, it wouldn't really qualify here.
Okay.
I also did a walk around on the house and checked our measurements and stuff. The house, I don't know if you got a picture of it up or not. Can you pull that up? Oh, for some reason or other, we've never assessed all the dormers on this house, and that's a line item as far as doing our job. So that's something we need to look at again next year also, and correct that, so. But I know I can't raise the value on it this year, but I wanted to make note that we do have some mistakes in the property that would raise the value.
Tell me why you'd raise the value again, Dick?
The dormers on that second level,
Yeah?
you see the 3 dormers on that side, and there's also a large dormer on the other side if you go to the other photograph.
I didn't know those were called dormers.
Yeah, they are. They're actually, they're quite expensive to build. And it's not their fault. It's our fault. We should have had them assessed from the start.
I'm surprised. I'll have to go back and look at the drawings, but I thought they were on the original sketch.
Well, they probably were. We just never had them picked up, Casey. It's, like I say, it's not your fault. It's our fault, and we will correct it for next year. If you go to that map on my second page there, you'll have to take it out and look at it. You will see the Peterson's property is in yellow. They're surrounded by quite a bit of ag property. But you'll also see all the parcels that are circled. These are residential parcels, the same as the Petersons. If you look at the assessment on theirs, 142.2, that's exactly what the rest of them are all assessed at, and they have been assessed at that going back many, many years. Everything that's circled is residential. It's assessed exactly the same way as the Peterson's property. Now, if you look at the other sheet I've given you, the first sheet, you're gonna see the history on this property. Going all the way back to 2006, this land has been assessed at 142.2. We haven't done anything with it. Apparently, they came in 2013 and got the land reduced. Basically, what that did is de-equalize their parcel with everybody else in their neighborhood. And I'm not sure why. It has a draw running through it, but it's a 10-acre parcel. Most 10-acre parcels in the Black Hills suffer from some kind of topo. That's just the way it is. So, I'm not sure why it got reduced, but it did. Like I say, it de-equalized them with everybody else in their neighborhood. If you look at the next page, you're gonna see a grid. If you guys wanna pull this up, the comparable sales. These are sales from all over Pennington County. They're not just in their neighborhood, but they're very, very identical houses. If you make adjustments to them, the biggest thing here is the land. One of these parcels is over north of New Underwood, so the land value is a lot different. If you make adjustments to all these parcels and compare them to the subject, he would have a value of about $344,000 for market value. You can blow any one of them up if you want to, but they're very similar. I looked all over the county for story and a half houses. So
Can I ask a question? When we asked for comparables, we were given the one sale on Moon Meadows Road.
on just the land, yeah.
Yeah, that's what we, that's all we
I
got.
haven't had any contact with you guys since you appealed.
Yeah, I've talked to you a couple times.
Casey's, it sounded like he actually gave you a break. He didn't include those comps. He didn't include that living space.
I'm not
And-
suggesting we raise the house either.
No, I'm not saying we're doing it this year or anything, but I'm just saying he's given you quite a break of what he hasn't put on there at this point. So 322 isn't too bad for what Dick is telling you today.
This is just mainly to illustrate that their value, I think, is fine. I can make no recommendation to change it for this year, but next year we will look at it.
Mr. Chair, if I might, is the issue both the building and the land, or one or the other?
It's just, we
Well,
asked,
for this year, it's just the land.
So that the house isn't
Yep.
at issue?
They're okay with it, and for this year, I'm okay with it.
And I'll say one other positive. You didn't put it in ag, and everybody else is around you, so I will commend you for that. You're paying your fair share of your taxes, so.
Talking about it.
We try to, and we don't have a dispute with the building, and if they come in and have additional items they've made a mistake on and explained, that's okay. I will say one thing, and I don't want Dick or Shannon to take this wrong, but I think my wife was told that if you appeal this, we're gonna have to go back and reassess. And frankly, that was a threat. I didn't
No, it was
appreciate it.
not a
Well,
threat.
it was taken as a threat. And I think that, your card that you put out says you provide superior, I think it says superior customer service when asked questions. And my wife did not feel comfortable at that point.
I apologize for that. I didn't mean to make you feel that way.
Our concern is the property. We all know that was a Walmart area that values went high. Just because everybody's assessed at $144,000 doesn't make that the right assessment.
But the surrounding area, Mr. Peterson, is the average is about 142.
And you go across the road to the west where there's trees and beautiful views, and there's $10,000 and $11,000. So is there a chance that that whole area is overvalued? As I said earlier, I think 50% chance that it is. In terms of the land, I don't have a dispute on the building.
Any other comments?
Mr. Chair, I have a question about, for Shannon or for our assessor. 142.2, how do you arrive at that number?
It was based on land sales back about 10 years ago when we did that area.
Sales, we keep track of land sales in the neighborhood. Every year we look at the new sales that sell and check against the land values that we have.
With a certain quantity of land in mind? No 1 acre sale versus a 10 acre sale versus a 20 versus, I mean, you gotta be some bracketing in there someplace, right?
Absolutely, yes.
So you looked at comparable 10 acre sales,
Yeah.
some range 8 to 12 or something like that.
Yeah, size does make a difference in real estate, and it makes a difference in different neighborhoods. So we certainly have to adjust for those differences.
Okay. And then using it as a starting point, then do you make adjustments for location?
Well, yes, but doing that, we try to find sales in the neighborhood, and then we don't have to make an adjustment for location. But if there are no sales in the neighborhood, we have to look elsewhere and then make an adjustment for location.
Thank you.
Any other questions? Comments? What's your wish?
I'll move to keep it the same.
Is there a second?
Second.
Motion and a second. Any further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed?
Aye.
3 to
Thanks for your
1.
time.
And I would like to apologize to Petersons if, like I say, if I offended them in any way at all. I did not mean to.
Okay, thanks, Dick.
Thanks, Dick.
Okay, next item.
The next property owner on the schedule is Vance Turman. He has canceled his appointment. Kurt has a comment on that, and then we'll go to Bryson.
Since they canceled, we're recommending no change to the $216,500 assessment.
That'd be my motion.
Second.
Motion and a second. Discussion. Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Next item.
Well, I'm Ruth Bryson. This is a hard act to follow. Previously, the guy lives in the same Vista Park condominiums that I do. However, I do think that I have a significant reason for the appeal. I have information, if I may approach you and hand you a copy of this information.
Thank you. Oh, is there two? Oh, there we go.
Thank you.
Thank you, ma'am.
Thank you.
My original statement of appeal was because in 2010, we purchased to own condominium at Vista Park. There were no rental condo properties at Vista Park. Fairway Hills Management in 2011 turned Vista Park into a mixed transitional rental property with owner condos. Going forward, the statement that I have provided to you with the information, there is a spreadsheet on the back of this information that was provided to me by the Equalization Office with a comparison of assessment, sale price, etc. In 2010, we purchased condo 4029 on the second floor at Vista Park, Fairway Hills Drive. Our condo was purchased for $224,000 or $183 per square foot, which was sold by Fairway Hills, Mike Buckingham, as a purchase-to-own condominium. At the time of our purchase, there were no rental condos at Vista Park. Thus, the price of the condo was not in a transient condo rental building, and the value of the property assessment in year 2010 was $210,300. In the same year, 2010, one other condo, 4023, was sold on the second floor with the same floor plan but with a larger deck. Sale price was less at $222,500. In 2010, the other number 4057 condo sale was an outside corner unit on the third floor. Third floor condos were priced higher. It has a larger deck, a fireplace, and more windows. This is important. The condo 4057 was purchased from a previous owner, not Buckingham Delora Inc., for $255,000, but now assessed at $175 per square foot, and our condo is assessed at $177 per square foot. Condo 4057 has a higher sale price value per square foot, $201, but currently has a lower assessed value at $175 a square foot. 2011, Vista Park Management, Mike Buckingham, started renting condos at Vista Park, decreasing the value from a purchase-to-own property to a rental property. Rentals of condos continue to this day. Also, in 2011, another outside corner condo, 4047, on third floor sold for $238,000 or $199 per square foot. Today, that property is assessed at $178 per square foot. Condo 4047 sold for a higher purchase price on third floor, more windows, fireplace, larger corner deck, and less noise factor. Assessed price for 2015 is $2,900 less than assessed price of $216,500 for our condo. Condo 4047 was assessed at a lower value of $213,600, prompted equalization questions. I had a meeting with Gordon and Dick Marquesca to apprise them of this assessment and to ask questions on reasons for assessing this property at a lower value. I did a measurement of my deck, and it was 30 square feet less than the 4047 condo's deck. They could not explain the assessment other than they had taken the square footage from the original plan. Since 2011, 4 condos have sold for sale prices lower than what we paid for our condo in 2010. 2 Vista Park condominiums have sold for a higher price than our purchase price in 2010. One condo was 4033 on the second floor, in which appliances, window blinds, and new, better quality carpet were included in the sale price. The condo has the same amount of square footage as our condo, but additional amenities. The sale price was greater, but has the same assessed value. We had to buy appliances and window blinds in addition to our condo sale price. Thus, the sale price increase to $234,000 for condo 4033 was due to extra amenities that were provided by Fairway Hills, Delora Inc. The other condo, 4045, that sold was on third floor for a higher purchase price of $226,900, but has a lower assessed value of $211,100, which is $5,400 lesser assessed value than my condo. Again, this is a condo on third floor with a larger deck, fireplace, more windows, and less noise factor. The point being that the sale price for condos at Vista Park has decreased from our condo purchase in 2010, with the exception of one, 4033, which included appliances, window blinds, and new carpet. Please see the spreadsheet provided by the Equalization Office showing year of sales price and 2015 assessed value. The assessments made by the Equalization Office have varied from $210,300 in 2010, $158,200 in 2011, $181,800 in 2012, $165,000 in 2013, $190,200 in 2014, and now $216,500 in 2015. Therefore, I ask for a personal appraiser to come to Vista Park and give me a more accurate appraisal. No measurement of exact square footage was taken. Dick Mariska came out to Vista Park and voiced that he clearly saw and understood my reason for asking that an accurate assessment be made in 2015. I met with Dick and Gordon after he visited me at Vista Park, and they offered me a reduced assessment of around $9,000 less than the now assessed value. I responded by continuing to request that the assessed value be what I consider to be fair, 2014 assessment of $190,000. I did not appeal the 2014 assessment, thinking that the Equalization Office had made an honest effort to arrive at a fair assessment, even though assessments had been lower and all over the place for several previous years. I was advised by Dick Mariska that there was no need to appear before the City Board to appeal the assessment and that the County Board would make the final decision. Therefore, I did not request a City Board appointment for appeal. I received a copy of the form objection to real estate assessment, to real property assessment, signed by P. Sumption, recommended no change. I called the Equalization Office to find out what was the meaning of this notification. I found out that the Equalization officers had recommended no change in my property assessment, although I had been given a verbal offer by Dick Mariska and Gordon, Assistant Director of Equalization. I was informed to make an appointment for appeal to the County Board. Sale or market prices of condos at Vista Park have been subjective depending on the seller and the buyer purchase agreements. Sale prices have decreased from 2010 with the exception of the 3 sales as previously described in detail with variable amenities, sellers, and purchasers. The condos were built in 2008 with no improvements or additions to increase their value. The assessment value continues to increase without regard to age of building, decreases in purchase prices, and now and since 2011, Fairway Hills has transitioned from purchase to own condos to also renting condos, which has decreased the value of owners' condos. This is indicated by a decrease in the majority of sale prices in the last 3 years. As proof, see the attached spreadsheet by Equalization Office. I make an appeal for the County Board to perform due diligence on the assessed value of my property for 2015. Thank you.
Thank you. Any questions by the commission?
I want, Mr. Chair, to be clear what you think your value is. You've had a lot of figures. I just want to make sure I understand what you think the value, assessed value should be.
Well, because of the variation in years prior to 2014, it went up from $165,000 in 2013 to $190,000 in 2014. So I felt, as I said before, that I thought the Equalization Office had made a fair assessment, it finally arriving at what I thought per square footage was appropriate. And
Can I just get an amount, please? What do you think?
$190,000,
Okay.
What's your square footage, ma'am?
1222,
What was that number again?
1222,
Thank you.
1,222.
Thank you, yeah.
Any other questions?
Based on what you're saying, ma'am, the 1222 units are selling in 2009, 237, 2014, 234,
Excuse me.
2014.
That one included the blinds, appliances, and new carpet.
So all the ones that have the square footage you have that have sold for average 222, have all been redone? Based on the paper that you told us to look at, ma'am?
I'm sorry, would you repeat that question?
You said your square footage, ma'am, was 1222,
Yes, ma'am.
and the ones that are sold with 1222 on them, are 212,000, 222,000, 234,000, and 209,000.
All of which, except for the 234,500 one, which included the extra amenities that I described, all of them have sold for less than what I paid for mine in 2010. So the prices have gone down.
Say that one more time, because this has the selling price on,
Right.
and say what you said again, why they went down?
Okay, the one number, condo number is 4033, sold for 234,500. That is a comparable property to my condo with the same square footage on the same floor. However, included in his sale price were all of the appliances, which I would say, I think we paid around $8,000 for appliances. In addition, we had to buy window treatments, plus he got brand-new, better grade carpet than what we got. So all of those amenities were paid for by Fairway Hills, Delora, so they upped the sale price to him to $234,500. All other comp square footage properties, and even some on third floor that were originally higher priced and have extra amenities that mine does not have priced lower than what I paid for mine in 2010.
So all of these that are assessed at, in 2015 at 216 like yours with the same square footage, except for one that's 196,500? Did you notice that?
Which one are you referring to?
Anything with your square footage?
Oh,
ma'am?
he has handicap exemptions, quadriplegic.
So you have 4013, number 4013 is 216 assessed, 500. You have 4033, 216, 500 in 2015. All of these have 1222 on them, 1,222 square feet.
Right,
Same.
but they sold for lesser price.
Not based on this,
Which one are you referring to?
all of the ones with your square footage.
You got my sheet there? in front of
don't
you?
think
My
so.
handout?
I got
Because
this
this
one.
is her sheet, yeah.
I'm reading her sheet.
On my handout, it goes by each floor. If
Right.
you want to look at that, it might clear it up.
But I'm just saying you assessed what she's saying on her paper the same way that hers is assessed.
I believe so, yeah. If they're the
That's what
same
I'm
size,
saying.
they'll be assessed the same way.
Right, and they sold for around the same price.
No, less.
What? I'm,
One of you talk.
This is your paper and it
this is your
says,
paper and
Yes,
it's on
ma'am.
there.
and it doesn't say less, ma'am. It says sale price, sold price, 212, 222, 224.
I paid $224.
Okay, thank you, ma'am.
Mr. Chair, if I might, does each one of those units have a share in the land? Or is it, 30,000 is assigned, of land is assigned to her, according to my sheet here. That's right.
All the units in there, 24 of them will have the same land value
Okay.
at 30,000 each.
Then that is equal. So even if you got a third floor, you still got part of the land. Thank you. So all we're talking about is the value of the part, or the value of the condo.
Yes,
not-
sir.
So the land is,
It's a fixed rate.
okay, thank you.
Any other questions?
Okay, so,
Dick, do you want to proceed?
I do. First off, I want to clarify something. When she said that she was read through the city, when I went out to visit her, it was like a day before or 2 days before the city boards. And I did talk to her about that we wouldn't have time to work up an appeal for the city boards, and that we would refer it onto the county boards. And she was okay with that.
Yeah, I was okay with that.
Okay. I just want to make sure that was clear that, okay?
You're doing good.
No harm, no foul.
All right, and she did take me out, I went through her unit, it's very nice, and she also showed me the corner unit. And it does have more windows, fireplace, it is different, a little bit smaller in square footage.
Bigger deck. Bigger deck.
Yeah, oh yeah.
Lots bigger deck.
I should go back, I'm getting ahead of myself here. We had Mrs. Bryson's property assessed at $216,500. I'm gonna recommend that we go to 215,700. That is just correcting the deck size. Okay, so the amount we're talking about is 215,700. And if you go through my sheet there, it's the same sheet as she has, except I've gone with the sales to assessment ratios. Every floor, we seem to be assessing very close to market value. I think we're over on one sale, which is very good. Overall, we're at 96%. You know, we're assessing every single unit exactly the same. We had quite a bit of discussion about that. Mrs. Bryson thought that the corner units should be assessed as corner units and the inside units should be assessed as inside units. Well, if we do that, we're all over the place. We don't have the same value on per square foot as we do. It basically de-equalizes this apartment. So we've treated them all as outside units and assessed them all as such. And that works. We're at market value with these, or close to market value. If we were to do it a different way, we would not be this good.
My recommendation would be 215,700.
Is that a motion?
Yes, sir.
Is there a second?
Second.
Motion and a second. Any further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Thank you. Okay, next one is,
I'd like to make a comment here. This is the end of an era. Dick Maresca is going to retire in about another month. He has been doing these equalization hearings for, I think, 27 years?
Wow.
22 and a half.
It feels like 27.
Over
He did
20
work
years.
for the county in the jail for a while before he came to Director of Equalization's office. But 22 years he has done these equalization hearings, and he was just talking yesterday about not ever going to have to do this again.
I brought him a cake. I'm just kidding. A chocolate cake. We'll put candles on it. I don't know if we have 22 candles, Dick, but.
So that was the last assessment appeal argument he had to deal with ever.
Oh, awesome. Thanks for all your hard work. Awesome.
give him a hand.
And you won. Yeah, cool. Not that I should say it like that, but I
Okay,
think
then,
you
the next one
treated
on the
fair.
schedule is Jack Batchelder, and he is here.
Okay.
You go right ahead, sir, you have the floor.
Okay, I guess my, appeal is based on the fact that my property in, I think it was 2013, was assessed at, I don't remember the exact numbers, but I think it was about 153. And then the following year, it jumped, about 40% to 215,000, which just seemed like a pretty incredible increase in property value.
Okay, anything further?
I guess I don't know what I'm expected to tell you.
Okay, Kurt, do you want to?
Yeah, last year, there was a reappraisal done in West Boulevard, 2013, and it went on the books for the 2014 assessment. So, there was, all the properties saw big jumps in the neighborhood there. And Jack just missed it last year coming in, I assume, right, Jack?
Right, yeah,
Yeah.
I wasn't paying attention that day. The mail came, I guess.
Yeah, and we didn't have a lot of people come in from the boulevard last year. We had some come in, but that was the reason for the jump, was the reappraisal in the neighborhood. Did you have anything more you wanted to add, Jack?
In August of 2012, I refinanced my home, And the appraisal that I got, it was through US Bank, and the appraisal that the appraiser did for them, the value was 154, which is very close to the prior assessed value.
Any questions for Mr. Batchelder?
Mr. Chair, the 2013 assessment was what again?
154,000?
And you missed the.
I have a copy of that assessment if you,
But you missed the appeal time last year.
correct?
Yeah, it went up 100,000 in 2 years. That's a lot.
I'll give-
100.
I got some handouts I'll give you folks.
2013 to 102. If it was 154 appraised in 2012. Was that our tax appraisal or your appraisal? What was the tax appraisal assessment from the county in 2013 by chance?
That was the information I got on Rapid Map. So I don't know where that comes from.
Would be interesting to know in 2012 and 2013 what, do you have that by chance, Kurt? Okay. Because you had yours appraised in 2012, so maybe we have what that 2013, what we assessed you at.
Yeah, I don't have that in front of me either, so.
Luann's going to try to pull it up, Kurt. Thank you.
I did, while we're waiting for that, Jack came in and talked to me at the office, and I did go out and do an inspection of the property. And I do have a recommendation of $195,700.
Thank you, Kurt.
You bet. And the comps there are good comps, and I'll go through them here. But if you want to look at the values first.
Give me just a second.
Mr. Chair, I move that we approve the assessor's recommendation, $195,700.
Second.
Motion and a second.
What's the assessment? I appreciate you guys.
500.
And what's the next year? Yep. So 2013, you went from 155 to 214?
Mr. Chair, we have a motion. Second.
Yeah, we do.
We're discussing on the motion, George.
Okay.
Mr. Buskerud. Am I correct?
Yeah.
Yes.
Okay. We have a motion and a second. Any further discussion on the motion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed?
No.
Carried.
They brought you down to 195.7. Is that right, Commission? Instead of the 216
Okay, and is there a way I can appeal that?
to the state?
Sure.
Am I correct?
Okay.
If he wants to appeal the 195?
We can go to the hearing, office hearing examiner or the state, yeah.
Yes, through the state, sir.
Or to the court, yeah.
Kurt, did he get those comparable repeat sales? Because those are probably important for you to look at.
Yeah, I gave him a copy, and his is showing an appreciation rate of 4.6% per year from when he bought it till now. And on your last sheet there, it shows the repeat sales showing the percent per year increase on appreciation rates. And after I did the inspection and made the adjustment, and these comparables, I feel are good comparables. I feel that the percent increase per year since when he bought it till now is a reasonable increase. And I know he took the big jump last year, but that was from the reappraisal. But if you look at over the years, the percent increase per year has been a reasonable one.
Okay,
Done.
we're done, aren't we?
Done, yeah. Done.
Thanks, Jack.
40,000.
Okay, we'll move on.
That's a lot of junk.
This is Tyler Wedding. and-
Lettering.
Oh, sorry about that. He's the attorney for John Leonard. Leonard.
Whenever you're ready, you can proceed.
Okay, thank you. As Mr. Doran said, my name's Tyler Wettering. I'm here on behalf of John and Mary Leonard, and we're appealing the assessed value. I shouldn't say assessed value, I should say the classification of their Pennington County property. I don't know what you have in your materials, but they have a number of parcels.
We have quite a little material.
Which are, most of which are contiguous to each other. And the basis for Mr. and Mrs. Leonard's appeal is that their property is taxed as non-agricultural when in fact it's used for an agricultural purpose. And I guess the relevant statutes, as you guys know, set forth 3 criteria for agricultural property, either income, principal use, or size of the parcel, and you have to have 2 of the 3. In this case, they're contiguous parcels, and their big parcel there on the bottom, that curved one, those meet the size requirements for agricultural property. And then the second point they meet is the principal use being for the raising and harvesting of timber. And John, I believe, has, I know Mr. Doran has a copy of this, I don't know if you guys do as well, but the forest stewardship plan.
We do.
That Mr. Leonard had prepared to basically, set forth a plan and spell out how to best raise and harvest this timber for the purpose of, generating income, being a good steward of the land, and raising and producing timber. And that's the primary purpose. It's the only purpose for which these lots are used is for the,
You read that letter?
in his notice of appeal? Yes, I have
Does
his letter.
specifically say that he bought that to break it up and resell it.
It said,
It's a little difficult for me to think
Sure.
that his primary purpose is egg when he himself says that. Can you respond to that question?
I can respond in saying that while his intention when he purchased it may have been for resale, this property is now used for, the raising and harvesting of timber. This
I'm
forest
going to
stewardship.
also talk to you about
Sure.
your stewardship.
Yes,
The stewardship plan does not say that it is for forestry, it's for preserving what he has. There's a whole difference in preserving your landscape as opposed to setting up to do.
well, I will, direct your attention, it's not numbered, but I believe you're probably on page 11, 12? In the first paragraph says site index, and then it has prescribed treatments for each lot.
I read it.
And, you'll see the prescribed treatments are to reduce fuel loads and produce a future stand of commercial timber, to produce commercial-sized trees as soon as possible. And I think in there is, a plan set forth for the commercial production of timber. It's kind of hard, especially in this area, because of the pine beetle infestation, to have, you can't just step in and have an immediately
I'm really
commercially
aware of that.
available.
Very
So
well.
if he has a timber plan, if his primary use is foresting timber, isn't that one of the 2 requirements of ag?
It could be, but it isn't the main requirement. His timber is in there to control mountain pine beetle damage.
And
that
that's
is
part of
not-
producing, a
yeah.
commercially viable forestry operation
That's
is first
r-
eliminating the pine beetle infestation.
I'm real aware of how that works,
Okay.
but I'm not going to argue with you anymore on that. I'm just saying that it isn't quite, the original stated purpose is really not to have a timber property. It's an ancillary to controlling mountain pine beetle. But what bothers me is in his own words, he says he didn't buy it for agricultural purposes. He is not using it for agricultural purposes until it's taken away, and now he wants to change.
I disagree that he's not using it for agricultural purposes. I think the stewardship plan makes it clear that he is now using it for.
But you have to get past his own
Sure.
statement.
And if I can, I would say that, his intention when purchasing it may be different than it is now. It doesn't mean you can't buy something for one purpose and change your mind.
And when did he purchase it?
So and I guess I don't know 100%. When I think, some of them were acquired over periods of time.
Oh, Joe, what was this property before Mr. Leonard bought it?
Looks like the purchase date was 2005.
Okay,
And
so was it ag when he bought it? Or was
I
it,
do not know the answer to that question off the top of
how
my
long, when was the ag taken off? Or was it just this year or 2014?
I believe it was taken off 2 years ago.
Otherwise, it's been ag all the way up till then.
But you didn't come in last year.
No, I did not. And I don't know if Mr.
So it's
Leonard
okay
did
to
either.
not be ag last year, but it's not this year.
I'm not saying that. I didn't know Mr. Leonard last year.
You think he's owned it around 10 years? 2005, Joe, is that what you said?
Yes.
It looks like on the one
So,
parcel I
do we
looked
have
at.
any bills that he's done anything? He's managing it. That has to cost him some money. Did he sell any trees? Did he ever do anything? No.
And I can say, from 2014, when this plan was put in place, that's what I'm asking you, guys to look at. I'm not arguing the prior values that they were assessed correctly or incorrectly. I'm saying now, with this plan in place, Mr. Leonard meets 2 of the 3 requirements to have his property taxed as agricultural property, and therefore it should be taxed as agricultural. And that's, his prior.
Does it say in the forest management plan how that plan has to be written in order to satisfy what you're saying?
Yeah, it has to be written for the purpose of harvesting timber, not for the purpose of preserving your property for your own use or for the sale of it. Because obviously, that mountain pine beetle epidemic and what it's done has decreased his ability to sell it. But that's not, he didn't have a plan, and the mountain pine beetle, we're in our 18th year, he's owned it for 10. If he hasn't been doing something with it, that doesn't indicate that that's really even legitimate either.
And I guess my response will continue to be that he has undertaken to meet the ag requirement of raising and harvesting timber. And I think this plan shows that. It contemplates the development of a commercial forest operation. I'm not saying that, immediately he can change gears and turn into a, full-blown lumberjack. But with this plan in place.
And he has many papers on the soils and everything else. So this plan is not just on timber, it's soils and everything else, Nancy. And
That's
because you
required.
guys changed it, now people are required to have a timber plan, soil plans and everything else. And I think by this paper, it looks like they have. And it's been ag until we changed our ag status. So
However,
now he's trying to apply and abide by your rules.
however, the law has been since 1978, that they have to have the main purpose as ag, and he has not had this as a main purpose. He hasn't shown any proof of it until this is 2014. The law's been in effect for well over that time period, and this was just helping those landowners to understand what it meant.
Because he's been ag that long. And then I'll just keep saying that. Because now we've changed and that ag law came up. I think a lot of people were affected by what you're saying on the ag law, not just this man. And so people having to come up and make forestry plans and different stuff for land that has no infrastructure, nothing on it. And then we're gonna tax them out of their property, so,
Mr. Chair, if I might, can anybody show me in this thick stack where there's evidence to support the part of the law that says the pursuit, the principal use pursuit should be for intended profit? Can you help me there a little?
And I'll just, go back to page 12 where it says, the
I
ultimate
don't
goal
got
is
page
to.
12 numbered. I'm sorry, you're gonna have to.
And I guess I should maybe count in and see
Well.
if it is page 12 since they're not numbered. But it says schedule of planned activities at the bottom of the page and the first heading says site index.
Oh,
And I believe it's
let me get-
11 pages in. "11 pages in,
Well, that is,
forest stewardship plan.
okay. Do I start with the plan as page 1, or where do I start as page 1?
Okay, I think, Joe, we'll turn this over to you for comment, and maybe that'll help us get it into perspective.
All right. As you can see, there are 3 different areas that we're talking about. On the bottom is the largest parcel, that's about 79 acres, I believe, 71 acres. Then there's all the parcels that are connected together. And then up to the north, between the 22 and the 23 up there is a smaller parcel. So I'd like to address that one first. And I'm recommending, of course, no change for all of them, but that one specifically does not qualify because of size, and there is no income. So that one, whether it has principal use or not, does not qualify, so that one is definitely no change.
and what's that number?
That is parcel 4369,
4369.
yes.
Thank you.
Then looking at, and that one has never been egg.
Okay.
Looking at all the ones that are joining there, I was on the property last week. I went up there and drove the entire road that has been put in there, so there is road and infrastructure to get to all of the parcels. There were a number of trees that were down on either side of the road, but they were the trees that had been removed when the road was made. I did not see any more cutting or chunking or anything as far as timber management on the property at that time. I did see a number of signs indicating where the lots are, and also on the very north end, lot number 4, which is the one in the top left, my left, that one, a sign depicting all of the different parcels that he has out there that are for sale. And so his intended purpose for this parcel and the other one is sales and to make a profit from the sale of the properties, not the timber, even though he does have the forest management plan. So he does not qualify on principal use or income. Therefore, I recommend no change to the egg status because of not qualifying according to the law.
Okay, any questions by the commission?
Yeah, Mr. Chair, I had another question about there's 19 or what, not 19, but about 16 parcels. Any idea how those all got put back together? Or was it all one unit?
I believe they were mining claims originally, so that's why they're parceled out in such a manner, and they were acquired by Mr. Weigert. They were not subdivided by him. You'll see on the description that they're old placer claims, or maybe they're load claims, but they were all subdivided back in probably the 1800s into individual mining claims. That's why they're all roughly 10 acres.
Did you know, was it all these parcels purchased at one time?
I don't know for sure. I think they may have been acquired. I don't know if every single one was purchased in one fell swoop. They might have been acquired piece by piece, but I guess, I don't know.
Looking at just 3 of these parcels, particularly the ones that are conjoined, they were purchased all in 2005.
And he does say in his letter that he bought them together.
In 2005, okay.
He said he bought it all as one, as a
All.
retirement investment.
All in one as all lots as one, not one
I mean,
lot
the
that was
whole
subdivided.
group of
Yes,
lots.
okay, yep.
Any other questions?
I'd like to just add one additional comment to what Mr. Doran said about the lots being for sale, and I agree with you that it says that when he purchased those, he intended to sell them. And I think that intent, you know, is now to use them to forestry, but this increase to non-agricultural has skyrocketed the taxes associated with these lots. And I think part of the purpose for, you know, whether they'd be offered for sale is that it's hard to afford to keep those. When it should be taxed as agricultural, in part because he has this Forest Service land and because he meets the size criteria, when that's taken away, and which was why he needed to adopt the forest management plan in the first place, to kind of have something to show that it's not just me saying that I'm doing this, that I have a plan in place, is to keep the property as agricultural so he can retain it. And that's all I have.
Okay, any further comments? If not, do we have a motion?
Mr. Chair, I make a motion to uphold the staff's assessed value.
Is there a second?
Second.
Motion and a second. Discussion. Hearing none, those in favor of the motion say aye.
Aye.
Opposed?
No.
Motion carried.
Thank you.
Thank you. Okay, next item is Canada Ranch. Morning.
Good morning.
Good morning.
Thank you for the opportunity to speak. My name's Doug Albertson. I'm representing Canada Ranch. We're located southeastern Pennington County. This ranch was established beginning, or the idea, I guess, in 2011, early on 2012, and it's a combination of 3 different historic properties, or ranching properties, comprised of 27 some parcels, about 5,400 acres. It's been kind of it has been complicated with multiple parties, and there were some land swaps with the Forest Service just trying to block things up above the Highway 44 and below. So last year I was dealing with some of the tax part, or the property parcels were misidentified through either the Register of Deeds or through Equalization or wherever, and so I had to get all the numbers to coordinate and match existing. So then we got the notice for this year as far as the valuations. Part of the previous ranch properties, obviously the old homesteads and everything, so we started cleaning up some of these properties and tearing down some old buildings. The ranch is a grass-fed bison operation, so we had to re-fence all the pastures. As I got the 2015 tax year valuations, I was reviewing some of the valuations or assessments, and I had, I guess, initial arguments with the office as far as the valuation of buildings that were no longer on the properties, that had been taken off and removed and everything. So I had Joe come out and confirm that those buildings are gone, so those were taken off of the 2015. But then some of the other valuations of it's all ag ground or ag classification, but some of it is classified as cropland and some of it is pasture land. And I understand it's a state House bill or whatever of most potential use or something like that. But I made the argument that, I don't know if you're familiar with the Badlands area, but there's a lot of open badlands and sod tables and things. And we don't have any, farming, equipment even, or do any cropland, agriculture. It's all pasture. And so I made the argument to Joe. I took him to some of the parcels, and I understand how it is assessed through the state bill as far as they look at the soil layers, and if the soil is present that is compatible to cropland, it's assessed at basically $1,000 an acre versus $400 for pasture land. So I took Joe to several of those locations that were identified as a soil type that would be cropland, and looking across a badland canyon basically at a sod table that I'm getting, the ranch is being assessed as cropland, and you'd have to build a road to get a tractor up there to farm it. So I made he explained the process to me, and I kind of did my own research on the House bill, and I know that at the recent session, there was a proposal to change the ag cropland versus pasture land to actual use instead of projected use, and I believe that got defeated in committee or something.
Well, it was just it was a bill to provide funding to do a study in regard to comparing those two methods. So and
my
that was
argument
defeated.
with the board was initially to change those parcels that were assessed the value of buildings that are no longer there, which my understanding is done now, but then just that you as commissioners understand that the constituency is not happy with the idea that you're getting taxed on what you could potentially do with your land versus what you're doing with your land. It'd be like creating a sales tax for what you
it's
could be selling
frustrating.
versus what you're selling.
I totally understand that. I've been going to those Ag Task Force Committee meetings in the summer and listening to that. There's some problems with the way it's been put in effect, and I think that they're very aware of it. They just didn't get that bill through to pay for the study. So they will be addressing it again, and you might want to keep track of the Ag Evaluation Task Force and maybe attend some of those meetings this summer, because your input would be valuable to them.
One other topic on this, so when these properties were purchased, some of them were owned, well, 3 different owners, but they're all purchased under a conservation easement with the Nature Conservancy. And under the conservation easement that's on file with the property deed, the registrar's office, is that there's no allowable or farming, basically. They want to preserve it as pasture land and as ranching. So the deed on the property, ranch property, specimen, I think those conservation easements have been around for 60 years, and so far they've held up in court as far as, how,
I've heard that too.
What's that?
I've heard that argument last summer
However,
too.
Mr. Chair, I would think that the law would supersede
Yeah.
any of those kind of documents. But let me talk about the accessibility of cropland, quote-unquote cropland. The issue was raised back in March when we were in Pier, and if I recollect correct, the person from the Department of Revenue said that yes, there should be allowances made
You're right.
for inaccessibility, as you described. It might be really, really good farm ground, but you can't get there, reasonably get there. So there should be allowances made, and I would certainly concur with that.
That's what they said.
Yes.
So you're appealing today, sir, what?
Mainly the 2015 assessment, and my understanding was this is the process that you go to appeal.
And the 2014 was good?
Well, it was 2014, the county offices didn't even have the parcels right. Some of them were, taxes were being sent to the previous landowner, and we were getting taxed on some of the ones that weren't ours anymore, because it was a complicated 4-way trade with the Forest Service and everything. So I spent 14 dealing with making sure the tax ID parcels were the ones that were supposed to be there and straightening that out.
And how was 2013?
Well, 13 was, not all the ranch was purchased at the time. So
Okay.
it's been about a 2-year process of putting this ranch together of multiple parties.
Mr. Chair, can Joe square us away? Are you appealing land and buildings, or both, or what's?
As Doug said, that I did go down and look at the properties with him, and that's how I found out where Kanata was.
Thank you.
But
The main issue is
show
the
me,
land, or the main issue is the land assessment?
well, and also there were a number of buildings that were remaining on his parcels that have actually been removed. So I have done that, and I think that you may have a spreadsheet similar to this. And
I don't know, do we? The buildings you can take care of,
I
that.
took care of all the buildings, and I
So
also
what's left
made,
is the land.
I also made minor adjustments to soil type, to the pasture rating, not on all of it, but on just this small soil type that is indicative of not possibly, producing as good of land. I did go to the pasture rating on that. Also, the parcel, the little section where it's not really possible to get the tractor over there, the bison can go over there, but I did make an adjustment as well on that parcel from the crop rating to the pasture rating for that one as well. Those are reflected in this, the spreadsheet, and so those are the recommendations that I'm making, that we go to these values, which is a reduction of, I believe,
120,
100 and,
20 roughly,
yeah, somewhere in there.
or 110, I'm sorry.
So what's the total?
The
Joe,
total
please.
change,
Yes.
the original value was 1,541,100, and the new value will be 1,436,800.
That's my motion.
Okay, we have a motion. Do we have a second?
Mr. Chair, our Director of Equalization is approaching. Can
Waiting
I?
for a second so I can make a comment.
I'll second it.
Okay.
Okay,
I-
you're,
Just a brief comment in response to what George says. Joe has a recommendation for change that includes a change in the assessment of the buildings and the land. We cannot take care of anything. The board makes a change in assessment. Now, Joe has calculated what those changes would be, buildings and land, and brought it to the board. But nothing happens unless the board acts on it.
I understand, but if the buildings are gone, that's a no-brainer. I mean,
Yep,
just
but-
fix that.
But Joe presents that value of those buildings, so you have to now take that off, and that's part of what he has presented here.
And sir, you understand what he's done in order to make it fair on your property?
Well, I understand the procedure, yeah, but as
Of
far
course,
as,
nothing's fair, because we all want it cheaper, but I
well,
mean,
just the concept, I guess the main purpose was, or one of my main purposes was to let you guys know that, the ag cropland assessment, I'm assuming dealing with the Department of Revenue or the state, the law, House bill or whatever that does that, but I don't feel that it's a, equitable way to tax somebody on their agricultural land based on what they could be doing versus what they are doing with it.
well, I'm agree with you.
And at this point, it's accessibility. You shouldn't have to have a chopper to farm it.
Yeah.
And that's the issue.
And I did
Yeah.
make an adjustment for that one parcel.
Okay, thanks.
That one little area.
Okay. I think we're out taxing people's ag land.
okay, anything further on the motion? If not, those in favor of the motion say aye.
Aye.
Opposed, motion carried.
Thank you.
Sure.
Okay.
The next property owner on the list is Norma Henderson, and she has canceled her appointment, but Joe has a comment on that.
You paying him extra today?
Today is Joe Day,
Joe Day, not Richard Day.
and in a couple of months, it'll probably be Joe Day in Pier.
The guy that was here for John Lettner's
Leonard?
property initially had put in an appeal for Mrs. Henderson. when on a site visit, I did go onto the property and I looked at it. I asked her if she was trying to qualify for egg, and she said, no, she cannot. In all honesty, she hasn't done anything. But she wanted to have some documentation. She was gonna get together, didn't. So I'm recommending no change to her value.
That would be my motion.
Second.
Motion and a second. Discussion. All in favor, say aye.
Aye.
Opposed? Motion carried.
Okay, then we go to the second page, and we have an appeal from Dwayne Pankratz. And I don't have much comments. I was looking for a letter here, but I don't see it. We received a letter. It came from, it came with Dwayne Pankratz's address on it, but was signed by Ken Nash. There is an argument that Pankratz and Nash have about a highway lot that they think was never, when the state acquired the highway lot, it was never taken out of the acreage that Pankratz owned. They've been in contact with Luann in our office. It was taken out. It was taken out before Pankratz owned it. Our acreage, to the best of our knowledge, is correct. Everything is fine. We have tried to contact Pankratz and Nash and have had no contact, but because their letter referenced specific word appeal, we created an appointment on the chance that they might show up. Didn't expect them to be here, there's no problem, so recommend no change to the assessment.
That's my motion.
Second.
Motion and a second. Discussion. All in favor, say aye.
Aye.
Opposed? Motion carried.
The next property owner on the list is Glorine Hunt, and I believe she's here.
Good morning.
Good morning.
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 Morning. I'm not here so much for an appeal as I am to go through the next process, which is to provide information to you as to what our intentions are with 40 acres that we have 1 mile north of Johnson Siding at 22799 Norris Peak Road. It's been approximately 15 years since our last harvest, and we feel that managing our timber resources is necessary. Our next harvest will begin with thinning the weaker growth and marking trees that will benefit from less crowding. We will start with non-commercial harvest, eventually working toward the purpose of sustainable timber production. The plan will be to group trees of the same characteristics together. Further objectives will be to raise trees as well as to protect them from insects and fires while protecting existing wildlife habitats. As part of the plan to protect from fires, we will continue to run horses. I have 2 horses on the 40 acres right now. They are not a hobby. I want to emphasize that. We realize they are not livestock, but we do have to have them there for grazing down the fuels on the 40 acres, and we will continue to do that. This property can support 4 to 5 horses during normal rainfall years, but again, I don't see it as a hobby. It will be necessary to improve a bridge across a stream, as logging equipment will need to cross the stream during harvest. The stream also supplies water to the stock pond located on the property. Because the entire perimeter is fenced and there is live water and natural shelter as well as a barn with water hydrants, we do not rule out leasing the pasture for a few head of cattle during the summer. Per the Pennington County and South Dakota guidelines for ag classification, we believe we have met the written criteria and would like you to consider our application for ag classification.
Any questions?
So, Glorine, the information that you just read to us, we don't.
I'm sorry?
The information that you just read to us, we don't have that. Is there Okay,
can hand it
was it given to the equalization office?
I didn't either.
Okay, that,
They just brought it in today. Would you like a
Can-
copy?
well, I
hand it
listened
out
to
to
what she said, but I mean, it's kind of important if we were going to get eggs, talk about that we had it and that they had it, so.
Do you have a timber management plan? I mean, did you have? do you
I'm
have to-
working with Dave Johnson from Johnson Tree Service. He is a certified forester.
Okay.
And really what we aren't asking huge amounts of plans, but your intent, stated written intent is important to us. And this work?
I appreciate a written intent, but most people can do a written intent, but I do know Dave Johnson in the tree company and that. But do we have to have the plan in front of us? Because.
No. What we have said is that we would want a written intention sheet, which is what you have
Does that
done.
qualify as a written intention sheet?
We have said it would. When
Okay.
we went through that whole process, we said it would. So,
I'm not questioning you. I'm just questioning how we do our
Well, it's a
forestry
learning
plans.
experience for me, and I'm trying to go through each step as we need to.
sure.
Maybe there are more steps I have to go through.
Nope, it's not you. It's just I'm questioning our forestry plan intentions and how we determine our timber plans. But thank you, ma'am.
Anything else? Any other questions?
So she would qualify for ag this year or next year? Is
Unfortunately,
there
she does not
intent?
qualify for egg this year. There was no agricultural activity on the property. It does qualify on size. The income comes from a different source, so she only qualifies on size, therefore she does not qualify this year for egg.
So no change this year?
That's what I'm recommending.
That would be my recommendation. Thank you, ma'am. Thank you for your paper.
We have a motion and a second. Any discussion on the motion? If not, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Okay, thank you.
You're pretty hard-nosed today, aren't you?
So we are.
It scares me all the time.
You see what I'm saying? It's not her issue, I mean, she's saying the rules, but eggs killing me.
Next property owner is Pete Lean, and, yeah, and there's a representative here.
Morning.
Hi there. I'm Greg Schweiss with Pete Lean and Sons, and we have 4 different parcels that we're here to discuss this morning. They each have kind of a unique set of issues associated with them, so if it's all right, I'd like to address each individually. In the essence of time, we'll try to move through them as quickly as we can. The first one that I have on my list is parcel number 14727. 14727. That's about a 397 acre parcel west of Sturgis Road, Highway 79, that is within a number of other parcels that we have in that area. That parcel had been classified as ag for a number of years, and we recently started mining into that. And here's where I dropped the ball. I've been in this role in Pete Lean and Sons for about 2 years now. The person in our company who had previously handled this function, I think, used to meet with the department on a regular basis and let them know when we're mining into a new parcel that we hadn't previously been mining into. And conversely, when we would reclaim a parcel and convert it back to ag after it had been mined out. I did not do that on this particular parcel, and obviously that was my shortcoming. It's kind of that L-shaped parcel you see there in section 18. With the mining activity running through a small slice of that. It was reclassified, or has been proposed to reclassify it to non-ag in 2015. That takes the assessed value of that property from $31,100 a year ago
to 3.1 million or $3.2 million this year. So an increase of a little over 100-fold there. Our thought process on that particular parcel is we're mining, and I didn't measure the acreage, but it appears to me that we're mining on about 50, maybe 60 acres of that 400-acre parcel. The rest of that parcel continues to be held and used principally for ag purposes. There's a timber management plan in place, has even been before the county had that requirement in place. We've always worked with a forestry consultant and always done timbering. There's been timber harvest even the last couple of years on that parcel. So in terms of acreage, the vast majority of the acreage within that 400-acre parcel continues to be used for ag, but clearly, as you can see on the map, we're now mining through or have mined through about 50 acres of that particular parcel. Another way we looked at that is in terms of taking that parcel, and if you look at it in terms of aliquot parts, we could split that parcel into 40s, 80s, 160s, and I think you'd find that the mining activity was on probably about 2 of the 40-acre pieces within that 400-acre parcel, maybe 3. When you look at it on a map, it's kind of hard to tell sometimes whether we're just kind of touching the edge of another of the 40-acre aliquot parts within that larger parcel. So it's our thought or our contention that the principal use of that parcel, based on the number of acres, is ag. Now, clearly, I'm not going to try to kid you or myself and say that the majority of the income, or that there's more income from ag than there is from the mining activity. But the use of most of that parcel is clearly ag. If we break it into aliquot parts, probably 280 or 320 acres defined legally in aliquot parts is not being mined and is being used for ag purposes.
Mr. Chair,
Sure.
I'm sorry to interrupt you, but will you be expanding where you're mining in that parcel?
Right now, the current plan is to turn back east, so we may be just a little bit back into more of that parcel going east, and then even into the next parcel to the east within a couple of years. That's the current mining plan as I understand it.
Okay.
Joe, what is mining? Is that commercial? What is mining under?
It would be more of a commercial activity.
Okay.
Yeah.
Does he have to replat that land? Like the guy we did when he had his property
Again,
in
that's a
commercial?
planning and zoning decision that they would make. It doesn't affect whether or not I give them ag or do not give them ag.
Thank you.
Any other questions? Joe, you want to proceed?
On this parcel, as 3 of the parcels that I have, I'm going to say that this is Pete Lean and Sons mining activity. Yes, they are using part of it as ag, but the primary principal use of this property is for the mining services that they're providing to the community and others. So therefore, the principal use is not met in qualifying for ag. They do qualify on size, and the income one is not met because the mining is where the money is made.
If we were to split that using aliquot parts going forward, legal descriptions, so that we kind of separated the mining area from the ag area, does that help us get to the point where the rest of it then becomes ag and we've more narrowly defined the non-ag area?
Well, Mr. Chair, we had a lengthy discussion yesterday, and as I recall, I voted no on the same logic, and I'm still not sure that individual can't somehow divide the land without excessive platting fees, but yes, my position is, based on our discussion yesterday, that you can do just exactly that.
Would you agree, Joe, if he replatted it and put his mining different than his ag?
As it becomes
My
a different
understanding
parcel.
that Pete Lean and Son does have some property that is ag, is that correct?
Yes, we have considerable property in ag.
So if they were separate, I would assume that, and they qualified, that we would then be able to
But
do
today,
something to
today
that
they do not
effect.
qualify based on.
On the size, and because its principal use is mining and income.
Mr. Chairman, this is a tough question
It
because,
is.
you know, we all know that the primary use of that property is mining, but, you know, acre-wise, it isn't. So, you know, it depends on how you're gonna define principal use. And is that size alone, or is it money? It's very tough.
Virtually any rule man makes, another man can beat it. And they can legally beat it by eloquently describing, just like, the Stromers.
Yep.
They couldn't eloquently define, as I understand it, but these folks can. So they do it, then they're gonna beat our rule. And they can do that.
And that's certainly what we'd like to do going forward. Again, in hindsight, obviously, the last couple of years, I should have been sitting down with people like Joe and Shannon and talking about where that mining activity was taking place and where conversely we've reclaimed and converted land back to ag. It didn't do that, so we were gonna ask the commission today to at least consider that the majority of that land, from an acreage standpoint, is clearly for ag use and not for mining. But obviously, if that isn't something that's going to be acceptable and we need to move forward with that, breaking that down into adequate parts going forward, that's something we can and will do.
Well, Mr. Chair, with the precedent set yesterday, obviously we can't unset that, I guess, at this point, so we'd have to follow suit with what we did yesterday and say no.
If you want to look at the other parcels,
That's your motion?
That's, are we going to take one parcel at a time, or what's?
I don't know what you would like to do.
Yeah, I think you need to take one at a time. They'll all be different, won't they?
So I recommend, based on our precedent setting yesterday, tax ID 14727, I believe that's the right number,
Correct. Yes.
upholding our assessors.
Motion and a second. Any further discussion? Not, those in favor say aye.
Aye.
Opposed?
No.
Motion carried. Next parcel.
The next parcel I wanted to discuss with you is parcel number 52137. 52137, and this is just a little bit to the south and east of the parcel we just talked about. This is a 37-acre parcel, which, as I alluded to in some of my earlier comments, is an area that was mined out many, many years ago. It was reclaimed, which is a very extensive process of recontouring the land, putting topsoil back on, planting it, seeding it, planting trees on it, et cetera. This particular parcel is distinct from the other that we just talked about in that it has been classified as ag for a number of years now because of those actions that I just talked about and because of the fact that ag is today and was for the last several years its principal use. So it was ag through 2014, and the value of just the land part of that parcel, there's a small storage building on it too, but the value of just the land part of that parcel was $2,400 prior to this year. By moving it to non-ag this year, even though there was absolutely no change in our use of that particular parcel, that moved the value to $298,400, so over 100% increase. This one surprised us a little bit, confused us a little bit because we didn't change anything in the way we were using that parcel, and it had been ag for a number of years. Now, I know Joe and the department, their position is based on the fact that, as you can see on the rapid map, the aerial photo there, there's a conveyor that runs across that. The parcel we just talked about was up to the north, I guess, is a more accurate way to describe that, where we mine the rock. The area where we process that rock is to the east, all the way across Sturgis Road. So the conveyor is simply a process to get the rock from point A, where we mine, to point B, where we process that rock. That's the only thing that occurs on that conveyor. And that conveyor has been there for many years now. The alternative, which we've used at times in our history, is to truck that rock from where we're mining it to where we process that rock. And certainly we feel like the conveyor, number one, is simply a process of getting it from point A to point B, and it happens to cross that parcel. But number two is much more friendly and safe for the area because it cuts down the dust and the traffic from having trucks on the road moving that rock from the mining area to the processing area. And we've even gone so far as to make sure that that conveyor is covered to keep the dust down because obviously that's a big issue with the neighbors, and we're very in tune to wanting to make that work for everybody in that particular area. So that's our thought on that particular parcel. Again, we're a little confused as to why that would have been converted from ag to non-ag when there was no change in use and when we'd gone through the steps in previous years that we did to reclaim it and convert it back to an ag use.
Mr. Chair, if I might, that's 37.3 acres connects with other acreage.
It does, yes. In fact, the parcel just directly to the north of it is an ag parcel, but there's
Thank you.
several hundred acres of other ag parcel also in that same
Oh, it's
complex. I'll call it.
contiguous.
Mr.
Thank you.
Chair. Mr. Chair,
Yes.
has it been consistently in use, or has it been down sometimes and you weren't using that conveyor?
It's down for a day or two for repairs once in a while, but otherwise it's been consistently in use for quite a number of years now.
And I could be wrong on this, but I remember us a long time ago debating whether it was egg or non-egg, and there was an understanding that it wasn't being used at the time. And so I believe that's why it went to egg. And so now I'm kind of wondering do we have some kind of a record? I mean, that'd be in the last 9 years that it would have changed to egg.
Joe, what did you see on the property?
When I was on the property, I saw the conveyor belt, of course. I didn't see a fence around it to keep the cattle there or away from it. So again, I'm arguing that the primary purpose of this parcel is the conveyor belt for Peatling and Sons, and there's no income, so they only would potentially qualify on contiguous acreage.
So they do qualify for ag, or they don't, because of the
No.
conveyor belt?
Correct.
Well, I'll speak for the conveyor belt, because I was in the city, and instead of them moving their trucks in and out, they made a lot of neighbors happy by putting that conveyor belt in to cut the dust down. So they did it not to do a business for them, because they could have saved a lot of money just sending their trucks in. They did it for the neighbors, so I don't believe should be
Mr. Chair, I'd like to ask,
counted as a principal use as a,
I'd like to ask our assessor
Business.
what his feeling would be if it was a road
Yeah.
and an unfenced road. Would that make any difference if that were a road?
It would still be the principal use of the Peatling and Sons to get their
Even,
rock wherever they
even if
would.
there were cows standing on the road, pouting?
Mr. Chair.
If there was a fence to keep them there.
what I'm
perhaps.
saying
No,
with the.
no, they could potty on the road.
What I'm
Okay,
saying
wait a
is,
minute,
he
wait a
could
minute.
send their trucks out of the ag area, go to where he's saying, and still use that as ag. He
Correct.
doesn't have to have the conveyor belt, he doesn't have to have a road through there, he can send the trucks to the other side.
Right,
But
there
he-
are other ways.
He did this because it was for the neighbors, not for his property. So it's,
Mr. Chair.
Mr. Troutman,
I had Deb check to see if I remembered that correctly, and it was changed in 2009 to ag. And my recollection is that the reason was because they were not going to do the conveyor belt, they were going to change it back to ag.
And I unfortunately was not involved with
know,
this in
I put you
'09,
in a
so I
different-
do not know that history, but I do know that that conveyor belt has been in continuous use. I think we went under the road and created the need to either use trucks or conveyor belt probably about 10 years ago. So it's been in continuous use for 10 years or so at a minimum.
Yeah,
so when we put pipelines through people's property in South Dakota, are we gonna take away their ag?
And that was our thought too, is we're just conveying something from point A to point B across that parcel. So what happens if you run a water line across there to get water from one side to the other? You know, what's the difference
Or you can,
with
like I
this
said-
case? Or as George mentioned, what's the difference if there was just a road that just happened to go through there to get from point A to point B?
I'm gonna recommend ag status in there.
Mr. Chairman, my problem is, and I don't have any disagreement, I think, I agree with George, if there was a road there, I wouldn't count it. My problem is, you have to be using this for some kind of ag purpose, and I have not heard, I mean, that they're growing trees, that they're growing grass, that they have cattle there. I don't hear any ag. And so why are we gonna give it ag?
I thought he said they had cows going through there.
There's
No,
no
and
fence.
if I could clarify that, as Joe mentioned, and he's accurate, it's not fenced for cattle. That's part of the tree farm that we've developed, some of which is off of Deadwood Avenue, some of which is over there, and one of the department staff has been out since that was developed to look at that. So they have been out and observed that. Those trees have been planted for 4 or 5 years now, will be used in things like our reclamation efforts to save us money, and when we go to reclaim other mined areas, and obviously if there's excess trees, then they'd be available for sale.
So he doesn't fit the ag status, not because of just principal use, it's because he doesn't have timber plan and he doesn't have
The principal use
agriculture.
is the facility of the Peeling and Sons getting their rock to where they want it to do. The ag status, what I said was there's no cattle on it, there's no fence holding the cattle there or keeping them from going on there. And I didn't see any cattle at the time that I was on the property.
No, and that's never been our intent, is to graze that particular parcel. Our intent has been to raise trees on that particular parcel.
Mr. Chair,
Yes.
are you required by some kind of an agreement with the state to reclaim?
Yeah, there's very, very extensive provisions in our mine permits in terms of exactly what we have to do with respect to reclamation once an area is mined out.
So is what is happening on this piece of property in relation to your requirements of reclamation?
Yes. Yeah, we need, when we reclaim, of course, we need lots of topsoil, et cetera. We also need trees so that we return the land that we've mined to very near the condition it was before we mined it. The trees are an integral part of that. And this is one of the parcels, as well as one over off of Deadwood Avenue, where we raised some of those trees for that. As I mentioned, one of the department staff was out a couple of years after we started that tree farm to review all that activity.
The unfortunate thing is that reclamation is not ag activity. I mean, yeah, you're growing trees, but the requirement really comes from reclamation agreements. And I'm struggling with how you can say reclamation is an agricultural activity. So I just can't vote for it to be ag.
Well, the trees are for, you're right, our own use in reclamation. That saves us going out and buying trees. So we're raising an agricultural crop that we just happen to use ourselves as opposed to raising it to sell to the general public. Obviously, if there was extra trees there, we would consider that, but that isn't something we've done.
But that's still reclamation.
What we're saying, sir, is we shut down everybody else that doesn't have ag qualifications with those three principles, and yours is the same. Unfortunately, I don't agree with all the ag stuff we're doing, but we need to change it somehow if we don't like it, is the bottom line. Because I'm gonna have to be in agreement. I'm not agreeing with all these ag issues that we're having today with people. I think we're gonna, and it's not your fault, Joe, but it's the law by which we have ag qualifications. So I'll have to withdraw my motion, sir.
Motion has been withdrawn. Is there another motion?
Well, I didn't withdraw my second, but I'll make a substitute motion that I'll reverse our assessor.
Same thing.
Well, no. It was the same, but now it's my motion.
Much as I want
There's
it, I can't.
second to that motion. Motion dies for lack of a second.
Mr. Chair, I would make a motion to uphold the assessor's evaluation.
Is there a second?
Second.
Motion and a second. Discussion on the motion.
I do have one last question, Mr. Chair, and that's, what do you do with the vegetation that grows? I presume there's some vegetation on that 37.3 acres. What do you do with it?
Mine it.
No, the vegetation that grows can be hayed. We hay a number of our properties. We have not yet hayed that because there's trees on it. If the trees are removed for reclamation purposes, then absolutely we would hay that just like we do the other properties where there's good grass growth on them. We just haven't.
And you'd sell the hay for a profit?
Yes. Yep, we have done that historically, yes.
Thank you.
Anything further on the motion? If not, those in favor of the motion say aye.
Aye.
Opposed?
No.
No?
Chair votes aye. Motion carried.
The third parcel we're here to visit about this morning is ID number 64898. 64898, and it lies just east of Universal Drive near the Windmill Truck Stop. This is a parcel that was very complex. It just changed in terms of the number of acres and the dimensions of this parcel recently. It used to actually include part of Universal Drive,
that we realized through a number of significant efforts with paying surveyors and engineers and attorneys that Pete Lean and Sons actually own the ground under Universal Drive, both lanes from about where our office building is down to where our scale is. The parcel continued over to the west side of Universal Drive. We recently, as I alluded to, spent money with surveyors to have all of that surveyed. We worked with the county. We deeded the ground that we had owned under Universal Drive back to the county. And the county in turn vacated an old right-of-way, apparently where Universal Drive used to run through some of our land, and they vacated that so that we had clean ownership of that. So the end result was, after all that cleanup and us working with the county to do some of those transactions, we have one clean parcel now that lies entirely east of Universal Drive. That parcel is used entirely for grazing purposes. You see that outlined in red there. It's part of a pasture with the next parcel to the north. That's all one pasture unit. That next parcel to the north is in ag status now and has been for some time. The parcel we're talking about here had been in non-ag because of some of the issues I talked about. That parcel extended through the road and on to the west where some of our non-ag activity takes place. As I mentioned, that's all cleaned up now, so the principal use of that, without a doubt, is ag activity. We have a grazing lease on that with an area rancher. He grazes that parcel and the parcel above, as well as several other parcels, a total of about 887 acres that he leases from us. I know that the issue or the concern that the department had is, you'll see behind, that's the Trimac trucking business in the middle there. Behind that, you'll see a little area that's a white there. They ran out of room to park their trucks, and they asked us if they could start parking some trucks kind of on the fringe of our property there, which we agreed to. So it's, you don't know the acreage, maybe 3 or 4 acres there that they park their trucks on that we fenced off separately because there's cattle in that particular area. So about 3 acres of the roughly 61 acres of that parcel are used for parking trucks by Trimac, our neighbor. Not something we really long to do, but something we did to be a good neighbor with Trimac there. So we have a small lease with Trimac. I think we get about $2,000 a year for them to park trucks on that 3 or 4 acres. We have a much larger agricultural lease. That parcel, the parcel to the north, which I mentioned, is in ag classification, and some other parcels that same rancher leases from us. So we were able to do that through those efforts of cleaning that particular parcel up. Because that is leased for grazing and haying, and was grazed and hayed in 2014, it was interesting here, we had the big fires along the interstate a month ago that did a lot of damage in the Piedmont area, and the second one burned right up the interstate towards our property. When it hit our property, because that had been grazed and hayed and there was very little residual grass there from last year, the fire departments were able to get that fire out on that property. It was headed straight for Trimac and for the Windmill Truck Stop, and quite frankly, right for the office where I work, and I was standing there watching it, so I was quite pleased with that. So not only is the principal use of that particular parcel ag, as is the parcel to the north of it, which is classified as ag, but it, I think, provided a benefit in that particular case to a lot of people in the community by that land being used the way that it was and helping stop that fire. So again, we're requesting that be placed into ag status. We did file a application to have that placed into ag status a year or so ago, not quite a year ago, I think, and that was denied. But we believe that the principal use of that parcel clearly is ag. It's part of the pasture unit with the other ag parcel to the north of it, and we think it meets all the criteria for ag classification.
Joe? Mr. Chair, do we have any record at Equalization of that lease agreement?
I think we did provide that when we did the application. You recall? Yes, I understand.
Okay.
We did provide the lease. Sometimes we black out the dollar amounts just because we have leases with different ranchers in the area, and if that becomes public record, we just don't want to.
I'm not looking for the amount.
But the lease, yes, I believe we did provide that.
Any other questions?
Mr. Chair, if I might, the return on the grazing is about the same as the return on the parking?
Yes. Yeah, the parking wasn't intended to make money off of. The parking was intended to accommodate a good neighbor, Trimac Trucking.
But you're getting remunerated for both grazing
Yes,
and...
that's correct, yes.
And they're about equal?
Yes.
Okay, thank you.
Joe?
Again, the argument that I am putting up today is that the principal use of this is the parking lot and not the egg. It's Pete Lean and Sons endeavor to make money however they can, and that they would be using the parking lot to do that in this case, and not the agricultural aspects of their endeavors.
So does he have to subdivide it like we said on the other commercial property? He has to replat that, put the 3 acres in commercial, and then put 61 in ag.
Mr. Chairman, I'm going to make a motion to grant the ag exemption.
I'll second it.
yeah.
Yeah, this one I can go with.
I appreciate, but you should be consistent. If it's got commercial on it, even though he's not saying it without sounding bad, you have to treat everybody the same, because the guy that had the storage units and stuff, he had parking and stuff, and we called
It's
that.
the primary use of the property. And I believe that the primary use of this property is ag.
As part of the larger grazing, yeah.
Second
I
again.
do agree with that.
I think the 61 acres are, but not the 3 acres, that he said that was commercial, so
Any further comments on the motion?
I didn't know we picked and chose how many acres is on there.
there.
Well, have to be consistent. Thank you.
Any other comments? If not, those in favor of the motion say aye.
Aye.
Opposed?
No,
Motion carried.
The last parcel we have is parcel number 62481. 62481, and this is on the east side of town off of Creek Drive. It's a roughly, I believe, 40 acre parcel, maybe just a shade under that. And the issue here has nothing to do with ag or non-ag. The issue here, and it's certainly not significant relative to the ones we just talked about, but along that east side, late in 2014, we had to sell an easement to the Western Area Power Administration on 1.9 acres of that parcel, and that easement runs up the east side of that property, and of course restricts our use of that 1.9 acres on the east side of that property. So the valuation, in our opinion, of those 1.9 acres is diminished somewhat. It's not a significant number of dollars relative to the ones we just talked about, but it was something that we asked the department to consider, is the diminished value of the 1.9 acres that were subject now to the WAPA easement along that east side.
Any questions by the commission? Joe?
I drove by the property last week and looked at where the easement would be. It would be along where the yellow line is on the backside of that property. So in my opinion, that easement does not affect their property in any way. Also, they were compensated for that easement. The land value from 2014 to 2015 did not change at all. It's still the same. The only change in their assessment, the increase, was building that they added to the property, and it did in fact raise their assessed value. Based on the fact that the easement does not affect their property in any way, I recommend no change to this value.
that'd be my motion.
Is there a second?
A second.
We have a motion and a second. Discussion. Hearing none, those in favor of the motion say aye.
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 Opposed? Motion carried.
Thank you for your time.
Thank you.
Thank you.
Subdivide those properties, so we don't have to worry about.
Mr. Chair, the next property owner on the list is Pierce. Following that is Sigmund. Our office expects those people to show. We don't know if they will, but we thought they'd be here, but they're probably looking at 11 o'clock, so maybe a break is appropriate.
Motion to recess?
Second.
Motion and a second to recess until 11 o'clock. All in favor, say aye.
Aye.
Opposed? Motion carried.
We have 3 property owners coming up next. One of them we know won't be here. We'll see if the other 2 show.
I thought we
Thanks, Jan.
recessed.
And am I correct? Raymond Pierce is here. Okay, you proceed up to the podium, sir, and you get to talk first.
Good morning.
Morning.
Money.
I'm Raymond Pierce. My wife and I own the parcel that's outlined in red up here. We've owned it since 2000. We have been producing hay off that property since 2002. Pretty much the north 1/3 of it, maybe a little more, the south being steep and rocky, and you can't really get equipment into there. The hay usually goes to local neighbors, Steve Hovland, Mr. Darrell Hahn, Ron Vesley. They all have livestock that they feed with that hay, and usually the hay goes to them either on barter or they cut it on shares. It kind of depends how the year works out. We've produced anywhere from 15 to 40 bales of hay off there a year, depending on weather and moisture. There was 2 years during the drought time that we didn't produce, one because just wasn't enough grass to feed a baler. The year after that, we had quite a bit of thistle start popping up, so we didn't want to cut that and spread it around anywhere, so we spent the whole season and the whole year pretty much spraying for thistle. Probably got about 98% of it out. I'm still doing some yearly running around and spot spraying. Do have some equipment that we've been buying over the years, a tractor, a swather. I own half of a baler with Steve Hovland, who's my neighbor. So, we've been producing off of it, and we have over the 40-acre limit. We obviously don't make enough off of this to be able to make any kind of living off of it, so my wife and I both work, but so many of the small producers that I know in the area are working full-time jobs also, because that's the only way to pay the bills. So we were kind of disappointed when our ag status was removed last year. We're not quite sure why we don't qualify.
Okay, any questions for Mr. Pierce from the commission? If not, at this point, we'll call on Joe.
Thank you. As you can see in this, in the rapid map depiction where the road goes in, the property to the north of that road is actually hayed, as Mr. Pierce mentioned. I did kind of map that out, just see what percentage of that property is the part that they would hay, and it would be approximately 25% of the 58 acres that they hay. I asked Mr. Pierce, and he did say that they did get 28 bales last year in 2014. However, this again comes down to, does he qualify for ag income? The answer is no. The source of income comes from another source. Size, yes. He does qualify on size, according to South Dakota codified law. Principal use is where we come down to. The principal use of this property is not agriculture. It is his home, where he resides, and the haying is an incidental, secondary purpose. The principal use of his property is his residence.
Well, the rest of that property that we can't hay is steep hill, rocky. You can't get in there with equipment. You couldn't hay it. Over time, I wouldn't mind having some cattle out there, but I have to get the south whole border of that property cleaned up. There's old fencing down there that's a disaster from the prior owners through some of those trees. To get that up to snuff and fenced in, and it's been quite a project to clean up. Otherwise, there probably would have been times that we've had some cows out there. Like I say, I do a lot of what I do up there in conjunction with Mr. Hovland, who owns the property to the west there, number 20, and some other property on the other side of Norris Peak Road. He's put some cows up in his pasture at times. He's talked about we should put some cows out in part of mine because it's not hayable, but it's not fenced all the way around right now, and that's been kind of a problem with that. I mean, if we could get at and cut and bale the rest of that property, yeah, we'd be doing it.
Okay, any questions for Joe or Mr. Pierce?
So if you took off the property that he cannot hay, and you can see kind of by the topography, then would it still be 25%? Because then would his principal use be haying if you took off that,
Oh, if you
area
took
that he
off where
can't-
the trees are and stuff like that?
yeah, the area that he can't actually hay it? But I guess we could put
Well-
cows there, like you said, but.
The south side of the road is actually kind of a draw that goes through there. And so you really can't hay that part either because it's
Right.
too steep.
Well, if I got some of the rocks out of there, we probably could, but boy, there's some rock in there, boy.
I wouldn't want to have to drive the swather on it, but
So he took his ag status because he cannot hay the whole property.
because the principal use is his residence.
Wow.
When you say 28 bales, is that small?
Big round bales.
Round bales?
Big round bales, yeah. And that was last year. 2 years ago, we got a little more off of that. Boy, the first couple of years, we did really well. We were getting about 40 bales off of there, and then that drought came through for a number of years, and that slowed that down quite a bit.
Mr. Chair, wasn't last year kind of a record year for precipitation?
Last year, we had just gotten done spending a couple of years spraying for thistle, and, you know, there's a lot of patches that just was not good thick grass from all the spraying and cleaning out weeds and things, so,
Usually that doesn't.
you know, this
affect
year,
it.
things are coming back a little better, so.
Mr. Chair, just as a reminder of last year, we had a similar situation where people said that they wanted to run cattle on it, but they didn't have fencing up and so on. So it makes it really difficult for us to say that that ag purpose could be handled on that piece of property. And we even went through to some legal, further into some legal, what's the word I want to say? Legal actions with that landowner, and it was determined that it was not ag because there wasn't any fencing, and she had the same situation. They
But
did
did they
get a
hay?
few bales,
Did they hay?
a few
On it too?
bales, yeah.
He's saying 28 to 40.
Yeah.
Mr. Chair, I have a question for Joe. The two numbers on here, is the first number the land and the second number the house, or vice versa?
On this sheet right here?
On this one.
Oh, let me look at that.
The application
Yes,
sheet?
that's correct. The first number, the NACS, is the land, and the house is the $553,800.
The house is? Okay. So that comes out to about $6,137 an acre for 58 acres? How did you arrive at that?
The land is based on sales and comparable sales and the land value now.
In 50-acre chunks?
There is a comparable sale of about approximately 50 acres. I didn't actually look at that. I was just told about it a few moments ago, that it is comparable to this property that sold recently.
In the neighborhood?
It was Nameless Cave Road
So were you,
off of 44.
so Raymond, were you ag before the last 2 years, or were you not ag before?
Well, we've been ag since 2002.
2013.
Mr. Chair, I move removal, I move reversal.
I'm a second.
We have a motion and a second. Discussion on the motion. Any comments? If not, those in favor of the motion say aye.
Aye.
Opposed?
No.
Motion carried.
Thank you.
The next property owner on the schedule is Sigmund. They have canceled the appointment, but Dawn has some comments. And then Adrian has also canceled, and Joe will have some comments on that. And then we're done for the morning.
Good morning.
Good morning.
This parcel is 52999. The owners are Tim and Julie Sigmund, and this parcel is located out in Red Rocks Estates. The Sigmunds live in Maryland right now. They bought their house out in Red Rocks, and his job moved them. That's why they weren't able to be here today. She wanted to be here today, but couldn't make that trip. So I told her, she and I had had several email communications, and we included them with your packet so you could read them. I asked her, you know, anything you want them to know, you know, we can share with you. I recommend no change from our assessed value, and she just wasn't on board with that. So I said, well, you can have it considered before the commissioners, and I'll try to answer any questions you have about the property. But I am recommending no change of the assessed value of $422,000.
Any questions for Dawn?
Move approval. Or no change.
Is there a second?
Second.
Motion and a second. Discussion? All in favor, say aye.
Excuse me, Mr. Chair, I noticed a 10% increase from 2014 to 2015. Can you elaborate?
This area was part of a reappraisal project, and so the valuation did change. And stuff out in Red Rocks changed to varying degrees. It wasn't changed because of any information that was found to be incorrect. It was just based on sales.
Okay,
Thank you.
did you vote then, or do you wish to be recorded as a yes or no?
Yes.
So the vote was unanimous.
Thank you.
Okay. Next item, Joe. You're down here twice. You can either make two speeches or talk out of both sides of your mouth.
If you do the name search, and then do Adrian, A-D-R-I-A-N, and you need to put George.
This the same guy?
George was not able to be here today. He lives in Florida. He was hoping to make a conference call, but work has called him away, and so he is not able to be here today. He did, however, send a letter, which I assume that you have gotten a copy of.
Yes, we have.
And have you had an opportunity to peruse that, or? Okay. In conversations with George, this property is right next to John Letnert's. Can you zoom in on that a little bit?
Yeah.
Just the whole, just that, not that one. He owns these three lots right here, which is, as I said, right next to Mr. Letner's property. And so I was there. I drove on the road to the property and was looking at all the property in that area. I did not see any cut or chunked up wood. He ascertains that there is on the actual property, and he got his boots muddy, he told me, when he was looking at it to make sure that Frank Cross, who did his forest management plan, when he was checking on his work. I didn't see it. I'm recommending that there be no change to this property to A classification. He does not qualify on size. These three parcels are too small, and contiguously, they are still too small. He is in the process of having them platted, so they will total 50 acres, but that won't be until next year, or the assessment coming up. Income, his income, as he mentioned, he does have property in Tripp County as well as in Colorado that is ag income, but this property has not produced any income, which he attributes to the beetles and the natural disaster from that. And, but he doesn't have any income. His principal use, he says is timber, but I didn't really see any, and he doesn't have size. He does not qualify for ag, and that is my recommendation.
Any questions for Joe?
Mr. Chair, I've probably got it here someplace, but I can't find it. There's 3 parcels, right? And I've only got a sheet for 1 parcel. So what are the other?
What are you holding up?
There's 3 in a row, George.
3.
3 in a
Well, I
row.
got 3 applications, but only 1 sheet from the assessor's office, and you got 20.66 acres.
There should be 30.
I have like
I've only
41,
got 1 of these.
and then,
Do you need mine, George?
yeah, I
Just
got
give me the acres. You got 20.66. What's the other 2?
26.
Second one is 20.66.
Okay.
10.3.
Third one is 10.33.
Okay, thank you.
Any other questions? Do we need to make separate motions on each parcel?
I would not think that you would have to, because none of them qualify.
And they are adjacent parcels.
Yes. They touch each other. But when you add them up, it only adds up to 56, and the law states that it's supposed to be 80.
So how do you assess them then if it's non-ag now? How do you determine what the price that they owned on their land?
The assessed value,
Yeah,
based on sales, consistent with the properties that have sold there, and as well as in the
so
neighborhood.
there's properties in the area that sold in those pieces?
As well as those parcels himself, he bought those.
Okay.
Leonard has sold several of his, and Adrian just recently bought these. So there are sales there you're looking at.
Okay, and they were all the lots were worth 40,000, 39,000, pretty much.
We have these at the 10-acre lot at 33, and then the 39 for the 20 acres.
And Mr. Chair, did I hear you right? These are still platted?
They are platted as they are presently. In the future, there will be one.
Working towards unplatting them, is that?
He's replatting them into one. That's what I understand he's doing. I haven't seen the paperwork yet.
Can Shannon, can you read that law again about the,
As Joe stated, if it's platted parcel, it has to add up to 80 acres cumulative. And there's not.
I thought it was 40. Not 40?
well, the platting makes a difference and.
One parcel, minimum of 40 acres, or 80 if multiple parcels.
And George, just to, I know it seems like it does, but I have to tell you, I've seen it come through and the plating doesn't make a difference, so.
Well, that's why I want to read that statute again.
I know, but.
Just read it to us, could you please?
Yeah.
I'll be George for now.
You can be Joe. You've been up here too many times to change your name now, Joe.
It consists of not less than 20 acres of unplatted land, or is a part of a contiguous ownership of not less than 80 acres of unplatted land.
What does that
Same
mean?
acreage specifications apply to platted land. Got to be 80 if you're in a contiguous.
That's right.
Any other questions? Do we have a motion?
I'd move to uphold staff's recommendation on assessment value
Second.
On all three.
on all three. Yeah, I was thinking we were making one motion.
Okay, any other discussion on the motion? Not, those in favor of the motion say aye.
Aye.
Opposed, motion carried. Joe, I have one more question for you.
Yes.
On the Kanata property of Mr. Pierce. General location within the county, Kanata, comma, NBHD 470. What does that mean?
Neighborhood 470 is a breakdown that we use within our office to separate neighborhoods out, to help us to value them, as well as give ownership to each of the assessors for.
So that's a code number? Or?
It's a code number within our office.
Yeah.
Thank you.
Move to assess, or recess. I need more sugar, I'm going to sleep. Assess and recess.
Second.
Thanks for assessing us, Joe.
Have anything further, Shannon? Reminder of what? This afternoon?
Yeah, what we're looking at for this afternoon is Rushmore Resort, which is, can't think of his name, Jack Bratt. He will probably be here.
I bet.
Kurt Stonecipher, we expect to be here. Joel and Lisa Brown might not be here. Park and Trust, we don't know. Tyler Wettering is representing Rushmore Mall on the Target building. We expect them to be here, probably an attorney representing them. And then you're gonna take up Doffenbaugh's hangar issue. And then that's it for this afternoon, except that woman that wants to come back at 4.
Okay.
So with Jack Bratt and an attorney, we might be here till 4.
We're recommending no change. Donna does have some recommendations for the buildings on the property, and I'll let her address those at the appropriate time.
Thank you.
I'll back you up a little bit and describe this property. It's parcel ID 16153. It's located south of Keystone on Presidio Ranch Road. The Brants have 3 parcels totaling quite a few acres, and the other 2 parcels are ag. This parcel is non-ag. The Brants operate a Triple R Dude Ranch out of this location. So, was it 2 years ago, ag was removed from this property based on how it's used as a commercial venue. So that's kind of where that stands. Well, that also makes us look at the owner occupancy, and 100% owner occupancy was taken off of the property. It's currently at 76%. So that's why it's classified as owner occupied. The property is improved with the principal residence, which you see up there, a guest cabin, and a park model cabin that are used for the guests of the Dude Ranch, and 2 small outbuildings. When I was talking to Mr. Brand, I requested to come out and look at the structures, make sure our data was good, and if I needed to make any adjustments to the data on the property, to do so. And Joe and I both went out and visited with the Brands. I have a recommendation to change the assessed value on the structures from $137,300 to $111,800. The land value is currently at $100,400, which gives us a total of $212,200. And that's my recommendation. And I don't have a recommendation to change the percentage of owner occupied.
Thank you, Don. I guess what I have a problem with is that they both mentioned commercial use, and I'm really not sure why that is being tagged as part of the reason why that we can't get ag land. As most of you know, Ms. Hadcock, you and I were introduced to each other at the Lincoln Day banquet last winter, so, but the other members of the commission, I think, all know me pretty well. But we served on a committee that took quite a bit of time to develop some policies regarding timber. And what I want to do here is I want to pass this around. This is my timber management plan. We think that the principal use of this property is actually agriculture because of the timber, number one, because we use it to graze livestock, number two, and number three, we are involved in what is called agritourism. But I'm going to just hold this up. This is a sign of a certified tree farm, which we are. And certified tree farms, there's 4 things that they're supposed to do. One of them is wildlife, water, wood, and recreation. And we certainly meet all of those things. There's two forest plans in here. The one that I personally developed, and then one that the state forester did. And I'll just pass this around. This envelope contains the cruise data of the timber that was on not only this 80 acres, but the 240s that adjoin it. There's a lot of work that goes into these forest plans. And maybe you can have one of those. Just kind of look this over. You'll have an opportunity to maybe see what I'm talking about. We have been talking about agritourism in Pennington County for quite a while. And also the fact that the state of South Dakota recognizes agritourism as a legitimate ag business. I'm sure that many of you on the commission realize and know that. But I've got a couple of things here that I wanted to pass around. Unfortunately, I don't have 5 of them, but it does describe and explain what agritourism is about, and we certainly meet those objectives as far as the state law is concerned, and I highlighted it.
Nice check.
Things here on the sheet.
Thank you. So Joe, based on what he's said, why is it still not ag? Based on all those?
Agritourism is not defined in codified law 10-6-31.3 as qualifying part of principal use for ag status.
But it has timber cutting, timber stuff, and that sounds like his primary use in his hay.
The primary use is the commercial aspect of the dude ranch.
Well, I still, again, disagree for those 3 reasons that I've already given you. The primary use of this land, once you look at it, you can tell that it's really for growing timber. The fact that we have been in business in Pennington County for 33 years and been involved in agritourism on another piece of property, I don't think should have any impact on what we're trying to decide today. I'm really quite puzzled because 2 years ago I asked permission to come in front of the board and discuss agritourism, and it was kind of interesting because that particular agenda that was on that meeting, the county commissioners approved the request from one of the commissioners for reimbursement of travel expenses for economic development. That particular trip happened to be to Houston, Texas, that one of the commissioners went on. And I can say thank you for that, because we generated some business last year as a result of the trip down that the chamber and so on met. But I guess what I can't understand is we all know that timber is a product that you do not harvest every year. Okay, we've all come to that conclusion. The second thing is that just because somebody has some initiative and uses part of their land to do something else, in this case agritourism or trail rides, as Joe has mentioned, I can't see what difference that makes in the overall picture of the thing. The trail rides too, by the way, are probably 95% of those are on the Black Hills National Forest. And we have possess a outfitter guide permit, a special use permit on the Black Hills National Forest to operate this type of a business. Special use permits are fairly common, granted by the National Forest people. As a matter of fact, we happen to have 3, but the outfitter guide is the main one. To me, I see that special use permit being no different than a rancher who has a special use permit to graze cattle on the National Forest. The same thing should apply. If a rancher has an special use permit to graze cattle, does that mean that he's involved in something commercial? I don't think so. The principle is exactly the same because the authority allows you to do different things on the forest.
I believe his principal use is ag, and I think 161153 should be returned to ag. That'd be my motion.
Mr. Chair, before I go into a motion, and Jack, you're not going to like this.
I think we need to decide whether we're going to second this motion or not.
So second.
Okay, we have a motion and a second. Discussion on the motion. Commissioner Troutman.
One of the things you're talking about is your forest management. And you went to so many of those meetings, and we agreed that the purpose of the forest management plan was to create income from the timber. I'm looking at your goals and objectives. Not a one of them say anything about income.
Oh, it's right on the front page.
I'm looking at the front page. Where?
Someplace, Nancy, I'm not sure.
Well, your goals and objectives say nothing about income.
I should have highlighted it, but you can believe me that that's one of the first things that I put in there. I know that was, and it's also in the state plan.
Yeah, it's too bad you don't put it in your goals and objectives.
I'm sorry?
It's too bad it's not in your goals and
I think
objectives.
it is.
No, it's not. You can certainly look. There's nothing there about commercial timber sales or anything.
Wasn't that top one for that?
No,
Looking at that.
manage for healthy forests.
Joe, were you out there? Don, one of you out there? He's got a house.
Production?
Is that a bed and breakfast or just his residence?
When I asked them if they housed guests in their primary residence, I was told no.
Okay.
The guest cabin has 2 bedrooms and a sitting area, and then there is like a park model that's 2 units with beds in it, so they have, and those are the buildings that don't qualify for owner occupied.
I'm good.
But there's four
So you changed
spots,
it now?
basically. 4 beds.
Yeah, I think their website says they can take like up to 8 people or something like that at one time. So,
Yeah, I mean, what I'm
accommodate.
trying to figure out is that business really that big that it's gonna overshadow timber business, you know? Or is it just, more of a sideline?
I didn't ask those questions, and maybe I should have.
Also, if I might mention that these 3 parcels, 2 of the parcels that he owns
Right.
do have egg status on them. The 3rd parcel, the board made the decision to no longer allow them to have egg on that parcel when that decision was made. I'm not sure.
Thank you. 2 years ago.
Okay, we have a motion and a second. Discussion on the motion.
Mr. Peterson, what was the motion? I didn't hear it.
You want to state your motion?
To grant ag on the 161153.
Okay, thank you.
Any other comments?
Nancy, are you satisfied that we
With
met
yours,
the objectives?
Yeah, it's just kind of confusing when you have two plans and they mirror each other, but they aren't quite the same.
Yeah, in order to get certification, we had
With
to
the
go
tree
through
farm.
the state. But his objectives were followed by ours, and like I said, that's the first thing that we basically put in there.
Okay.
Yes.
And have you provided it to the Equalization Office? You've got it?
They looked at it when they were out at the ranch, and I gave them a copy. You asked and requested a copy of the state plan.
Okay.
He didn't ask for mine, but he does have a copy of the state plan.
Okay.
As
Any
you can
other
see, they're very
questions?
comprehensive. There's a lot of stuff that goes into those.
I'm
Other
aware.
questions on the motion?
Nope.
Okay, we'll vote on the motion, and then I have another question. All in favor of the motion, say aye.
Aye.
Opposed?
Aye.
Roll call?
Buschrood,
No.
Farabee,
Yes.
Adcock,
Aye.
Troutman,
No.
Peterson.
Yes. Motion carried.
Thank you very much. I
Now,
appreciate
do
it.
we need a separate motion to adjust to accept the adjustment in the improvements?
Yes.
They are all I guess it wasn't like that, because you were giving them egg back, so.
answer is
yes.
Yes, I would agree. Yeah.
Would you like the numbers again?
Okay, so
Make a motion to change the assessment of the improvements to 111,800.
there's a second?
Second.
Motion and a second. Discussion?
Mr. Chair, before we vote, and maybe you can wait afterwards, but the owner occupied still kind of bothers me. And obviously, no matter how long we stay on this planet, we keep getting educated. I thought owner occupied was residence, period.
I can clarify.
Please.
Statute 101339 addresses classification for owner occupied. First of all, it defines a dwelling, which is a house, a condo, an apartment, et cetera. It includes a garage or an attached garage, and it states that you can only have one dwelling in which you get classification on. It doesn't talk about any kind of auxiliary building, like if people have two garages, do they get it on the second? There's nothing in the law that talks about that. It says one dwelling and a garage attached or detached.
So it doesn't matter.
Okay, so that is consistent with what I've known it to be, is one residence, one dwelling. And I guess we learned here some time ago that you can have two lots, adjoining lots, but that's a different story. Anyway, how do we get to a percentage?
I think we're deviating a little bit from the motion. And am I correct?
Oh, wait, you are, so after we get done with the motion, I would still like the clarification for future reference on a percentage of owner occupied, but let's
Perhaps you
vote.
could meet with them individually to do that.
Well, we can vote on this motion, and
Okay, any more discussion on the motion?
This is the number you gave me.
If not, those in favor of the motion say aye.
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 Opposed? Motion carried.
Thank you very much. I really appreciate it.
Thank you.
You.
Okay, next item, Stone Cipher, is that correct?
Yes, Mr. Stonecipher is here.
My name is Kurt Stonecipher. My father and I own a property almost 160 acres north of Wall that has previously been owned by a family out of Illinois for years and years and years. They sold it to us, but it's a little bit peculiar because it's landlocked. There is an old section line that goes to it, but the section line has been farmed for years and years and years, so there's no actual road to it. My only access consistently has been foot traffic, so I walk a half a mile across the neighbor's property to get to it. Unless he's in a particularly good mood, he might let me drive to it. So that's the first, my argument today is that it's coming out of agricultural status and going into non-agricultural status this 2015. And I don't quite agree with that for multiple reasons. Those being, first of all, it's landlocked, I can't even access it. It has no perimeter fence, which means both neighbors graze it at will with their own cattle. And I can't stop that. I can't carry fencing materials in there on my back to fence it and keep his cattle out. There's no electricity, no water, no access, no perimeter fence, no improvements whatsoever. So it is primarily being used for agriculture, just not my cattle. And it certainly meets the size requirement for agricultural status. And then one other question I have is, why change it now? It's been in agricultural status for, well, since 1820 when it was first sold. And nothing has changed, so I don't understand why it changes now.
Okay, any questions for Mr. Stonecipher?
Yeah, and here's your two.
If not, Joe?
Bill?
It was suggested that I introduce myself again, as you may not know me. But you actually, we haven't met. I am Joe.
Who's he?
And I was out on the property last week as well. This property, as he said, does not have the perimeter fence all the way around it. It does have a fence that goes through it diagonally. And the property on my right, the right is then grazed by Mr. Dahl, and he uses that also to take his cattle across there to his other land. The property, the part that is on the left is grazed then by the shears. But from what I understand, there are no leases to that effect, and it's just his land. I have talked with the Register of Deeds, and as to their knowledge, there is no vacation of the section line, which is on the lower left south corner, southwest corner, going down through that field. Yes, there is no road, but there is a section line there with rights to go on that. And I actually asked Mr. Dahl about that when I was at his house trying to find the parcel and gain access to it. And he said he agreed that there was no vacation of that easement.
If I may interrupt, there is no easement on record. And when I spoke to him about traveling up and down that with a vehicle, his response was, well, there's gonna have to be some sort of crop damage reimbursement if I start using that road. Because he's been farming it. You can
It's
see
a
right there,
section line?
that's a wheat field right there, and he's been farming it for however many years.
Was he serious?
Well, yeah, when I first bought this and approached him, it was a little, it wasn't cordial. Things have gotten better since then, but he's still not eager to let me have vehicle access to this property.
But he gets to use your property.
He was serious about crop damage on public property.
Yeah, he was.
I'm going to
And
make the motion to grant ag,
Is there a second?
back to ag.
Second?
Okay, we have a motion and a second. Joe, in terms of the legal parameters for ag, you want to address that relative to this project?
There is size. There is not principal use, because even though it is having some grazing done on it, it's not his grazing, there's no leases, there's no income from that, as well as Mr. Stonecipher's income is not from this parcel of land. It does not qualify for ag. Additionally, because of the issues that he does have with access, we have already considered that and given him a 25% adjustment to his land for the access issues.
Mr. Chairman.
Yes.
I mean, it isn't one of these things that it's obviously ag land, except it doesn't meet the qualifications.
Yeah.
because it says, principal use is devoted to crops, all for intended profit. It doesn't say because there are wandering cattle roaming around on this property. It's, the owner has to be farming it for intended profit. I don't hear that.
I don't hear any profit, and I know this land's been since 1820, and we're gonna take it away. That's crazy.
If I might, Mr. Chair, there's another statute that I apprised this board of here on Tuesday, and it says if it's agricultural land, if it's used exclusively for agricultural purposes, and anybody going to deny that, whether it's his or somebody else's, it's ag purposes that's being used for. So that statute, in combination with the other statute, this one's more specific, so this one would override.
Yeah.
It's agricultural land, period.
Thanks, George.
So what was that statute again, please?
The one, I've got it out in the card, 10-31, whatever, but
Well, I
remember,
would like to know that before I make a decision based on something I don't know.
want to go find it?
Well, I guess we have never used that
George, sit
before.
down.
It's kind of interesting to hear it.
Sit down, George.
Statute book there.
I don't, I think Shannon might.
Shannon, do you have a statute? George?
I think it's immaterial.
I do too, but
I agree. If you're gonna rely on that exclusive clause,
We got real problems with a lot of them we've given to.
today,
Yeah.
well, this is pretty common sense to me.
Would you care to read that aloud for us, Commissioner?
It's gotta be.
10-6-31, classification of agricultural and non-agricultural property, notation by
Just-
Director
just-
of Equalization.
Just a minute. If we could have your attention, please. Okay, proceed.
For the purposes of taxation, all property is hereby classified now into two separate classes, to wit, 1, agricultural property, 2, non-agricultural property. Agricultural property includes all property used exclusively for agricultural purposes. It includes all land used exclusively for agricultural purposes, both tilled and untilled, the improvements on such land, other than buildings and structures, and the livestock and machinery located and used on such agricultural land. If you go by this explanation, he doesn't qualify.
He's untilled.
Tilled or
It
untilled.
says tilled or untilled.
Tilled or untilled?
The definition, classification of ag.
Tilled or untilled?
Well, if we want to go by that, we better go back and look at a whole bunch of them we've given ag to, because they're not used exclusively for
Yeah.
agricultural purposes.
No, but this is
Yeah, we
another
could get
definition.
and Mr. Bratt would be one.
You can, if you're going to use the definition, you got to use it for all of them, not just the ones you pick out. They got to be used for all of them then.
You take the two statutes and try to harmonize them. That's a Supreme Court word, is you take the statute that you were reading out of and this statute, you try to make them work together.
No, George, you try to make him to work to what you want to decide.
I think we all do, Nancy, so I'm not gonna argue that with you.
All right.
Any other comments? We do have a motion and a second. If there's no further comments, we'll call the vote. All in favor, say aye.
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 Aye. Opposed?
All right.
Aye.
Okay, 3-2, I think.
And carries.
You want a roll call to make sure?
No, I think everybody
okay?
Waste of time.
What's the law on that?
No, we don't play the
I'm
law here.
pissed
We
Stop
disregard
it.
the law around here. We don't care.
If it's for government, probably.
Okay, the next one up
Thank you.
is
Thank you.
Brown, are they here?
No. We don't think Brown will be here. Parkin might not show up and isn't here now, but a lady representing the Rushmore Mall is here. So let's deal with the two. We got Rushmore Mall, and then Doffenbaugh is back with his fancy airplane hangar. And deal with those two since they're here, and then we'll back up to those that aren't.
Is the
think that-
airplane fancy or is the hangar fancy?
I was gonna say it's a tractor.
I don't know, we can only
or-
see the building, we can't see what that airplane looks like.
I see. Maybe there isn't one.
Who are we on now?
We're going to do Rushmore Mall, the Target store.
Oh, okay.
Am I missing Rushmore Malls or what?
Oh,
Thank
I'm
you.
not finding it.
Oh, I think I've got that.
probably.
Yeah, I,
Thank you.
36853.
Yeah, I got it right
Probably
here.
ours.
Oh, yeah.
Yeah,
Sure.
I don't have it. Perkins.
Hello, my name is Kathy Kerr, Operations Director for the Rushmore Mall, representative for the Simon Property Group. I am here to represent our notice of appeal of the 2015 estate assessment notice referred to in the above-mentioned parcel. It is parcel 20-25-226-004, map 003-6853, and before the County Board of Equalization level of appeal. The subject property is 101,559 square feet of GLA, formerly the Target store, situated on approximately 10.25 acres of land located at Rushmore Mall, 2200 North Maple. The subject property closed in October 2008, was actively listed for sale, and it was sold to SM Rushmore Mall LLC on October 2014. According to the Pennington County Real Estate Assessment Notice, the subject's property's proposed 2015 assessment is $1,650,000. We believe that the proposed market value is excessive based on the evidence provided in this narrative document. You will find attached Exhibit 1 and 2, the executed buyer and seller settlement statements. The total consideration for the subject property was $650,000. Also attached, Exhibit 3 is the First American Title Insurance Company commitment number NSC 681345 MPLS, which ties to the file mentioned on each settlement statements. Exhibit 4 attached is the executed Certificate of Real Estate Value, SDCL 7-9-7, showing that the actual consideration exchanged of $650,000 and that there was no relationship between the seller and the buyer. In 2011, Target appealed the subject property to the Office of Hearing Examiner utilizing the asking price of the closed dark subject property as evidence and attached as Exhibit 5. We now have a sale price to prove what the market bears. Based on the evidence, we respectfully request that the subject property's proposed 2015 market value be reduced from $1,650,000 to $650,000. We thank you for your consideration. I will not be answering questions. All questions would need to be levied through our property tax department. Juan Paz, he is available by cell phone if we need to refer for questions.
Okay. Any other
I do.
questions or comments?
Mr. Chair, I do have some questions. And you can answer them. So, my question is, JCPenney recently moved into that, and I know that they're leasing that, and I'm curious as to what the lease amount was, or is.
I do not have that information.
That's what I thought. Because I think that is probably indicative of the value.
Okay, R3.
Yes, sir. I have several sales right in the area of the subject property. And I got some comparisons. And if I may give you another little handout other than that sheet that you have already.
Certainly.
Thanks, sir.
Thank you.
Thank you.
There are comparisons on top of the subject property, JCPenney, Sears, Herberger, Shopko, Runnings, and so forth, and the square footage, the age of the property, the land value per square foot, the building value per square foot, and so forth. And the $650,000, even based on the comparable comparisons of similar property, really doesn't add up, I guess. And there's sales listed below that. And these are properties that actually sold. And there are 3 properties right behind the mall that are much smaller. The first 3 listed there that I have behind the mall there, one is where the state office buildings moved into and so forth. It's a newer building, sold for $1.3 million, but that was an unfinished building when it sold. There was no interior finish to that, and so they had to finish that after it actually sold, and there is a permit for the finish. The other one is an office building that sold a while back in '09, but it's only 10,000 square feet, sold for $1 million. That's behind the mall. These are within a block of the subject property. And then there's the little church building directly behind Target there, only 6,415 square feet, that sold in for $640,000. Not even close to the subject property, building, land, anything. I've got Runnings, which would be a similar type structure and similar type building. That property sold for $3,750,000. And that was in not good shape when Runnings bought it. They had to do a lot of remodel to that. The city building down here, just off St. Joe, just down the street from us, and so forth, sold for $1.4 million. That's just a warehouse building, and so forth. So, I mean, the $650,000 really is a question in my mind of, it may be the price that they paid, but I do not believe it's market value. And there's a big difference between the two. And I have land sales listed below there also, and they're bigger acreages. The subject property has 10.25 acres, and I've got sale or acreages all the way from 3.41 to 25.37 acres there, and they're all above the $3 per square foot that I have on the Target property, which comes out to our land value is twice of what they paid. So I mean, there are real questions in my mind as to how the mall and Target got together on this kind of a number. And what is actually market value. I don't know whether they had a market value appraisal done, and there are just real questions in my mind. And I believe our value is right in there. I did some examples of some of the subject property with even as a comparable property on top there, like the JCPenney building. We have $12.97 per square foot on that property, and that needs to be redone. That's they moved out of there now, and they're going to redo that one. And even if you use that number, the value on the subject property would be $1.3 million. And so if you use all 4 of them except for Herberger's there, I mean, it would come out to $1.8 million and so forth, $18.08 a square foot. I mean, I have my examples there. I have sales of properties that are much smaller in square footage that sold for much more than the subject property, the old Target store. So I feel our value is right where it should be at this point.
Any questions?
Mr. Chair, if I might, these numbers you have for Penny's, Sears, Herberger, Shopko, and Runnings, they are okay with those numbers?
Yes.
Okay, thank you.
Any other questions? Ma'am, you indicated you could not answer questions, but do you have any further comments?
I can tell you that JCPenney is in that building on a temporary basis only.
Okay, thank you.
But a long time for temporary. I mean,
Okay,
1 year?
any other questions? Do we have a motion?
I move to uphold our assessor.
Is there a a motion and a second? Any further discussion on the motion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed? Motion carried. Do you wish these back?
Was Nick?
Please, yes.
you want,
If that's okay.
Yeah, I
It's
can,
gonna end up in here.
I think you've already got copies, but I'll.
If you want to keep it, that's fine.
no, go ahead.
I don't know where the rest of them were, but.
Did you get a copy of this?
You need your stuff back? I save it, read it at night.
Give her a copy of yours?
Okay, thank you.
Campfire.
Thank you.
Use it as a sleep
He
aid,
dreams
huh?
about assessing.
Mr. Doffenbaugh is back. The other two property owners haven't showed up, so I'd suggest you go to his, the airplane hangar that was rescheduled till now.
So, since he's back, is it acceptable that we do not repeat anything that was said previously?
Second.
Okay. You have the floor.
I might have made an extra copy of that. Got this, Joe.
You don't get one, Joe, you have to guess. Here's memorization. Oh, you're giving him one, okay.
Yeah, thank you for letting me continue the statement here. I did learn a lot yesterday. Understand that now that the bigger part of the 550% increase is the changing it from the ag purpose. I think it's too bad that there isn't kind of a mix of the two. I've never said that the hangar wasn't, the airplane wasn't the purpose that I built it, but I do have mowers, log splitters, the Bobcat, the skid steer loader in there that I do use quite a bit for the ranch there.
But the land value isn't actually the question, because the land value is still ag.
Right. I did learn one thing yesterday. It wasn't clear. I mentioned I didn't know where that number came from on the building permit. But I didn't think I had anything to do with it. I know now where it came from. I called planning and zoning, and they say they assign a number to the building permits. I guess it helps them keep track of the value of the building permits, the track.
Oh, wow. So I was wrong. I apologize.
I feel that Joe is still high in looking at the cost and the value of the property, especially the hangar door. I know that some of them are up over $25,000 for a door, but this door cost me under $1,800 for the material to build it.
I did also call an acquaintance of mine who builds pole buildings, and I asked him what the cost was and he gave me a cost per square foot of $4 per square foot. So a 40 by 40 building, which is what the permit was for, is $6,400. He said it also depends on the amenities that you put into the building as well. That being said, it would also qualify for the door, as Mr.
Doffenbaugh.
Sorry about that. Doffenbaugh. Stated he and his wife did the labor on this, so he's not taking into account that aspect of this building. There is a replacement cost new, which does include that labor. And so the values that I have given you on this sheet in the replacement cost new are consistent with a hangar that would, and what it would cost to replace this one new. And then I've just highlighted a couple of the differences between the hangars that I was able to find. Some of them are much older, but when you bring them up to be equal to this hangar, the replacement costs new are relatively the same. The other thing about an agricultural building versus a hangar, an agricultural building is going to be used as such. They're going to run some cows in there, they're going to run their tractor in there and accidentally hit the wall. When you're running your airplane in there, you don't accidentally hit the wall because that damages your airplane, you can't fly it. There's a difference of consideration, and that being said, an agricultural building is going to depreciate considerably more and be much less of a value than a hangar. Again, I will go back to my recommendation of changing it to a pole frame building and with the building value at $26,800, keeping the land value the same for a total of $36,000.
Any further comments or questions?
The comparable hangars here are all much fancier, like Joe said, the amenities in there. I really don't have anything. The other examples he all have electric power and probably power doors, power-operated doors, and concrete floors. And I know that at least 3 of them have insulation. One for sure is heated. Maybe all of them are, I don't know. And I don't have any of that, just the shell, the protection from the sun and the no.
But the amounts are quite a bit higher for those too.
What was your building permit for? What was that building permit? What did they price it at?
27.2.
$27,520.
That'd be my motion,
Well, no.
is to do it at $27,520. Since he doesn't have the amenities, he doesn't have the same thing, and
That's
the
higher
doors
than
are
my
smaller.
recommendation,
Thought you said 36,000.
total, including the land,
You're down to 26,000 for the building?
26,800.
I thought your whole total was 39,000.
He
36.
I don't have that sheet anymore.
That's what I said, my
Okay.
whole,
39 was what it came out with the assessment.
and my
values.
old total was 27,520.
What?
So
For
then
the
you're
whole-
you're only
with the
giving
building and-
18,000 for the building.
Yes. I think that's pretty.
Oh, yeah, that's what you're doing, is 27 for, oh, okay.
Yes, sir.
And I would second that.
Can I make a recommendation, you round that to the nearest 100?
Okay, 27,000.
I would second that.
So, Mr. Chair, may I have clarification? If we're going to do 27,000, how much is it for the building? How much is it for the land? How much are you wanting to do?
Did we say 18,000, Buskerud?
Well, the land is 9,000.
Okay.
The land will stay the same.
Yep, and the building's worth 18 then.
God, she has no idea what she's doing.
Second.
Okay, we have a second, but we need to,
What is it?
stabilize the number.
You're saying total 17,800, correct?
27,000.
Total is 27,000.
18,000 for the
27,000 minus
barn and
9,200.
9,000 for the,
So we're going to change the land.
The land's 92.
land's at 9,000.
Okay, let's let Joe quote us a number
Okay,
when we
It's
get,
9,200 for the land and 17,800 for the building, for a total of 27,000.
okay, you
What
got
the
that, Karen?
motion is for.
yes.
Okay, so that's the motion, and we do have a second. Any further discussion on the motion? Hearing none, those in favor of the motion say aye.
Aye.
Opposed?
Aye.
Roll call.
Buskerud,
No.
Farabee,
Yes.
Adcock,
Yes.
Troutman,
No.
Peterson,
Yes. Motion carried.
Yes, thank you. It's obvious this isn't an easy job here that you have.
Thank you, sir.
Okay.
Well, it's easy until we have to deal with airplane hangars, and then that just totally screws our day up. Backing up the schedule, we have two property owners that haven't shown up. Joel and Lisa Brown and Parkin. Joe has comments on each one of those. I suggest you deal with those, and then the board, I understand, is going to wait for the lady coming in at 4.
You never know, I may have a motion on that one, too.
Well, you can do that.
You
We're-
haven't-
We're all going back to our office when these two are done, and if we're called, we'll come back down.
Joe, is the only one they argue is on yours all the time, or what's the problem?
I just don't give in. That's all.
You're not the sweet guy?
He gets all of the easy ones, so he can handle more.
There,
I
now
don't
the
know. I don't know
explanation
what
comes out, Joe.
But as
Okay.
Kelly says, I needed to introduce myself. I'm Joe.
That's why you need a new pair of pants. You probably wore them out walking all through these plans and parts. Or that's supposed to be your shoes, sorry, Joe.
The Brown property is the property that is on the rapid map right now. That's parcel number 64049. They are basically, it says that there's a power line issue, which they've already been, made an adjustment for that. They came to my office basically wanting to get agricultural status back. They do not make their income from agricultural, so they don't qualify there. They don't qualify on size because it's 39.88 acres. It is so close, and yet not close enough. And the principal use is agriculture, but they do not qualify for ag. I recommend no change.
Can they borrow some land, just the other point, whatever?
Then that guy wouldn't qualify.
Was there any taken out for roads? Can you tell?
No, it was purchased as 39.8 acres. He thought that he was actually buying 40, but there's been no changes that,
Wow.
it was 39.88 when he bought it.
Make a motion to uphold the Director of Equalization's value.
Is there a second? I'll second it. We have a motion. Any discussion? Not, those in favor of the motion say aye.
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 Aye. Opposed? Motion carried.
I should say aye, but, geez.
Unanimous.
The next parcel is the parking trustee, Dan Renner. He called our office and was asking about his properties. He owns the one there and the one just to the south of that as well. And he was appealing both of those. He has a majority of his property, of this property is cropland. So his property did go up because cropland went up 15% this year and pasture land went up 2.4. That's why he called in. And I explained to him how the soil is valued for agricultural purposes. And he wanted me to send a bunch of stuff. I did. And tried to get a hold of him a few times. His phone was kind of weird, but I left him some messages and I did write him a letter saying if you want an appointment, you need to let us know. He never called back, so we gave him this time anyway. He's not here, and I'm making a recommendation of no change to these parcels.
Move approve.
Second.
Motion and a second to uphold the department. And Karen, do you have the numbers of the properties?
yes.
Okay, any further discussion on the motion? Hearing none, those in favor of the motion say aye.
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 Opposed? Motion carried.
That's it. If the board wishes to stick around for that Pinion property, our staff will go back up, and if we get a phone call, we'll come back down for it. But that is everything that we know about needs to be done.
Anybody know, what does she want?
Kelly can speak to that.
So I'm Kelly. When I spoke to her, she was concerned about being unable to pay her taxes.
So am I.
Yeah, aren't we all? And so I went over the data with her house. I went to visit her house, and I showed her some comparable sales. She told me she didn't believe we should value based on sales in the neighborhood. But that was her concern, is she doesn't have any improvements to her house since last year, but she just can't pay her taxes, is what she explained to me.
Did she tell you, I mean, where are you at, 136.3?
I'm at 136.3, yes.
What was it last year?
Last year, we lowered it to 125.1. And I'm not sure what happened. She spoke to an assessor in our office, but I don't know what they spoke about.
I asked if the owner was old enough to qualify for elderly assessment freeze, and she's not.
Is there any veterans?
She hasn't said so. So, all of the tax break programs that are available, we don't know that she qualifies for any of them, or obviously doesn't. So, she's not paraplegic. She doesn't appear to be a disabled veteran. She's not old enough to be elderly assessment freeze. There is a homestead exemption, but that again, you have to be 65 or 70 for that.
Any thoughts?
Mr. Chair, Kelly, did kind of the surrounding area, there was just sales that were higher than?
Yeah, I can show you, Luann, can you pull up Rapid Map?
Love to, but can't justify it. Oh, like $150 difference.
My house is 109. That's with the one.
So the map that I'm passing out and that Luann's gonna pull up, that's 3 years of sales. She's out in the valley and there's a ton of sales out there. So we have her currently assessed at 136.3. There are a handful of lower sales in there, around 118, 115. I looked at all of those to see what was going on. Those are all foreclosures, which is why they sold so low.
Good sign.
That neighborhood's on its way down, so 125 would be just about right.
Yep. I'll make a motion to leave it at 125
Is there a second?
Second.
Do we need to reconsider or anything first, maybe?
Yeah, because
Since there was a
Reconsider,
motion, since
yeah.
there was a
Done
motion
anything with it, have
yesterday.
we?
Motion yesterday on it.
to wait till 4 o'clock.
But,
No, there was a motion on. There was a motion on it yesterday, so I think you should
Oh,
just
that's- yeah,
consider
that's
the.
Oh, go ahead.
I'll make a motion to reconsider it.
Second.
So, and I can show you the comparable sales that I found too, if you'd like to see those.
I don't think they care.
Made up our mind.
I don't think so.
Care, but with foreclosures and different things in the area, I believe that's kind of telling us something too.
There's foreclosures around my house. I live there too. So let's talk about mine.
You're the equalization guy, so we have to charge more, because you know the real price.
You are not on the agenda.
Could you fill out your paperwork and maybe we can see you next year, sir?
But me and along with everybody else out in that area though,
But no abatement.
there's foreclosure sales all over Pennington County. And Pennington County has, in comparison to most places in the country, very, very few foreclosure sales.
So is it difficult then to really base a value of a property on a foreclosure?
We still use those sales when we value property. But I argue about foreclosure sales and say that they typically sell for less, but it's not because banks dump them on the market. The bank I go to is as greedy as I am. They sell them for whatever they can get out of them and the most they can get. But foreclosure properties tend to be abused. If you are losing your house to foreclosure, you're not fixing the roof, you're not changing the floor cover. In fact, you're knocking holes in the walls and pulling light fixtures out and things like that. So when we go and look at these foreclosure sales, we find that they are worse shaped than the average property, and that's why they sell for less.
I don't think 125 is that low of a number either, between 136 and 125. It's not just because of foreclosures.
Oh, I thought you said that.
Okay, now, we're talking about a motion that was made yesterday.
You'd made a, we have a motion waiting to be
reconsider.
voted on to reconsider, so.
Okay, so we need to preface this with someone bringing it up for reconsideration.
Me and Busker did,
Okay,
made the motion.
We have a motion, no, just
I
no
thought
vote.
you had some numbers in there.
Sorry, sir.
Okay, the motion to reconsider, all in favor?
Aye.
Opposed, motion carried. Next motion.
I'll make the motion. Is it 125.7 or 125.9?
Last year, it was at 125.1.
Okay, that'd be my motion.
Is there a second?
I'll second it.
Motion and a second, discussion?
I hope it helps her make her pay her taxes. But I am concerned that it won't.
Yep.
Okay, we have a motion and a second. All in favor of the motion, say aye.
Aye.
I,
Opposed? Motion carried. Do we have anything left, Shannon?
No, that's it.
So we can adjourn instead of recess,
What if she,
As far as I'm concerned.
if we can get a motion?
what if she comes and she doesn't agree with that?
She can appeal to OHE.
She can go to OHE.
that'll cost her a lot of money though, won't it?
Yep.
Well, she can do it by phone.
To hire an attorney.
That's all we have. I don't know anything else you need to do.
I don't think I'd do any better than that either way. I was here at 4
Okay,
now.
do we have a motion to adjourn?
So she appeals that.
We should have went up.
I move we adjourn, sir.
I'd be crazy anyway not
Is there
to
a
take.
second?
your office, try to get a hold
I'll
of her and
second.
tell her.
We have a motion and a second to adjourn.
They already shut you
All,
off.
Okay, well, then she can be
You're
down
shut
here, I guess.
I vote yes.
No, I got Luann.
all in favor of the motion to adjourn, say aye.
Thank you, though. Micah.